Good morning. This meeting of the Agricultural Labor Relations Board is now called to order. Please note that all meeting participants and members of the public will need to select the language that they prefer to listen to this meeting in. You can select either English or Spanish. If you look at the bottom of your screen, you will see a button for interpretation. Please select which language you prefer. Even if you can hear me now, in order to have quality audio throughout the meeting, you will need to select your language preference to ensure you are able to hear the audio throughout the meeting. I'll give a moment for the interpreter to relay that as well. Okay, thank you. Next, I will turn to the roll. Board Member Broad.
Here.
Board Member Flores.
Present.
Board Member Hall.
Present.
Board Member Lightstone.
Present.
Thank you. Also present from our staff for today's meeting is our Executive Secretary, Mr. Santiago Avila Gomez, and the Assistant to the Chair, Mr. Ed Haas, who are providing technical support throughout the meeting. As we all know, while there is thankfully some light at the end of the tunnel, the COVID pandemic still persists, and protecting and ensuring the health and safety of both our staff and members of the public is of the utmost importance. Thus, in accordance with Executive Order N2920, today's meeting is being held via video conference with an option for members of the public to dial in. We'll first start with the business portion of the meeting, which I anticipate will last roughly 45 minutes. We'll then recess for 10 minutes and then reconvene and hold an informational panel, providing an overview of the H-2A worker visa program and contemporary issues. At the close of the business portion and the information panel, we will open the meeting up for public comment on any portion of the meeting. Members of the public who have contacted the board either by email or phone and asked to be placed in the public comment queue will be called on in the order that those were received. If you did not previously contact the board and wish to make a public comment at the end of the meeting, you may do so in one of several ways. You can make a request in the Zoom chat function or raise your hand, or you may email Santiago Avila Gomez to be placed in the queue for public comment. Please note, we ask that you use the chat feature only to indicate that you wish to make public comment and do not provide substantive public comment through the chat feature. We ask that you also provide your name and organization if applicable. This information will become part of the official record of today's proceedings. If you wish to speak more than once, please alert staff and have your name placed back in the queue if you are able. If you have technical difficulties at all during the meeting, when you are called on, please either reach out to us via Zoom chat or email, and we will come back to you. We do have limited capabilities to manage participation during the meeting and during the public comment periods. We do ask everyone, if you are not speaking, to please place your phone on Zoom on mute and wait to unmute until you are called to speak. You can also see these instructions on our agenda, which is posted on our homepage at alrb.ca.gov under the News and Information page. I'll also note, if you would like to see some of the reports that will be discussed during today's meeting, please go to the Meetings tab on the upper tab of our homepage. And if you select the second link, which lists the public meeting notes and reports, you can find a listing of reports for today's meeting. With that, we'll proceed to our first agenda item, which is approval of the public meeting minutes from February 9th, 2021. May I have a motion to approve the minutes?
So moved.
Thank you. Board Member Hall, may I have a second?
I'll second.
Board Member Broad, first to the buzzer. All those in favor, please say aye.
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 Aye. Thank you. The public meeting minutes from February 9th, 2021 are approved. Next, we need to approve the regional directors meeting minutes from February 9th, 2021. May I have a motion to approve the meeting minutes for the regional directors meeting?
So moved.
Thank you, Board Member Flores. May I have a second?
Second.
Thank you, Board Member Lightstone. All those in favor, please say aye.
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 Aye. Thank you. The regional directors meeting minutes from February 9th, 2021 are approved. Next will be the chair's report, which I hope will be brief. I want to welcome everyone again to our meeting. This is our first meeting for this spring, and we are just a few weeks past Cesar Chavez Day, but I did want to take a moment to acknowledge that day. It's an important day in California history. It's a time for us to remember and recognize a very pivotal figure, both in the ALRB's history, as he was a pivotal force in enacting and creating the Agricultural Labor Relations Act, as well as enacting the board and a voice for workers and Latino rights that we still remember today. And we choose to honor him by celebrating his birthday as a day of public service. I also want to note that Governor Newsom recently recognized another pivotal figure in this period of history by commemorating and recognizing and declaring April 10th as Dolores Huerta Day, commemorating her birthday and recognizing all of her great work. He did this a few days ago, and I was so excited to see that and recognizing all the work that she did in helping to form the United Farm Workers with Cesar Chavez and others, and again, helping to enact the ALRA. And she continues to be a strong voice for civil rights for all people. I was very fortunate to get to celebrate Cesar Chavez Day this year by attending an event with my colleague, Board Member Flores and General Counsel Julie Montgomery at 40 Acres in Delano, California, as we participated in providing outreach during a vaccine distribution event. I want to acknowledge the hard work of the United Farm Workers and many organizations who have been key partners for California in ensuring that the prioritization of farm workers for the COVID-19 vaccine is successful and ensuring that so many farm workers get that vaccine. It was a wonderful event, and it was such a great way to spend Cesar Chavez Day. As I'm sure is going to be detailed in the General Counsel's report, this is just one event that the board has been using as an organization to provide additional outreach to farm workers. We've been utilizing both food and vaccine distribution events to provide key information to workers. If you would like to have the ALRB participate in an upcoming outreach event, I ask that you reach out to our outreach coordinator, Daniela Ramirez, and you can find her contact information on our newsroom page on our website. In relation to outreach events, I'm excited to be speaking next Wednesday at the California Wine Grape Growers Advocacy Day and to reach out to employers to speak about their obligations and duties under the ALRA, and I'm looking forward to that event. Rounding out the report, as we have mentioned at nearly every board meeting since I have been present, and as I touched on at the beginning of the meeting, the COVID-19 pandemic is still persisting, as we know, is disproportionately impacting our farm worker population. This is something that has been of utmost importance to the board. We've been closely monitoring this. We've had several forums throughout our board meetings, and it's something that as a board, we want to make sure that even though that is not the focus of today's meeting, we are still monitoring what is going on with the pandemic and how we as a state are addressing the needs of farm workers. With that, I wanted to provide some additional information at the request of the board on some data related to the pandemic as it relates to farm workers. I'm pleased to share some enforcement statistics from some of our sister agencies. First, from the Labor Commissioner's Office. Since February 1st, 2020, and through the end of 2020, the Labor Commissioner's Office received 943 wage claims in relation to from agricultural workers, 77 field enforcement cases. These are cases they bring at their own discretion, larger impact cases, and 81 retaliation cases. So far in 2021, they have received 181 wage claims from farm workers, started 11 field enforcement cases, and received 20 retaliation claims. Relatedly, Cal OSHA, since February 1st, 2020, and this is specific to agriculture, so this is from the start of the pandemic through today, they've received 227 complaints, investigated 162 by letters, and opened 32 on-site inspections. They have had 103 accidents and illnesses reported to Cal OSHA and opened 29 on-site inspections. 35 fatalities have been reported to Cal OSHA and they've opened 23 inspections. They have received additionally 154 referrals. Those are by individuals, media, and other agencies, and opened 154 on-site inspections. Their total on-site inspections in agriculture alone, and this is specific to agriculture, this does not include food processing, are 320 to date, which is second only to healthcare, which has received 519 on-site inspections. I anticipate the General Counsel will speak more to the ALRB's enforcement efforts with respect to COVID-19. I can report from the board standpoint, we have not yet received a decision or an appeal related to a complaint stemming from COVID-19. Somewhat related to the pandemic, we had many of our hearings have actually settled during this time. The board did hold its first virtual hearing earlier this year. And with that, that is the close of the chair's report. We'll move on to the next agenda item, which is the executive officer's report on elections, unfair labor practice complaints, and hearings. Mr. Avila Gomez.
Thank you, Chair Hasid, members of the board. Since the board's last public meeting on February 9th, all of the following has occurred relating to elections, unfair labor practice complaints, and hearings. With respect to election activity, there have been no notices of intent to take access, notices of intent to organize, or petitions for certification or decertification filed. With respect to complaints, one amended complaint was filed, one complaint was withdrawn, and 4 complaints were settled. The amended complaint is filed in Cinegrow Farms, Inc., case number 2017-CE-008-SAL, involving vegetables in Ventura County. The complaint that was withdrawn is Duda Farm Fresh Foods, case number 2019-CE-011, that involves celery in Ventura County. The 4 complaints settled post-complaint settlements are in C&G Farms, case number 2019-CE-0033-SAL. They entered into an informal bilateral settlement agreement on March 8th. Dominguez Farms is the next case matter, and that case number is 2017-CE-033-SAL et al. That also has an informal bilateral settlement agreement. Anthony Vineyards is number 3, case number 2020-CE-004-VIS, also an informal bilateral settlement agreement. And finally, Santa Rosa Berry Farms, case number 2019-CE-050-SAL, also an informal bilateral settlement agreement. With respect to hearings, we had 1 virtual hearing, our first actually via WebEx. That was in Cinegrow Farms, case number 2017-CE-008-SAL. That one is pending before the administrative law judge, receipt of post-hearing briefs. In the time span between our last and current public board meeting, there have been no ALJ or board decision issued, but there have been 4 board administrative orders. Our board administrative orders, as well as our board decisions, can be found at our website at alrb.ca.gov. The 4 admin orders, 2 each issued, 1 in United Farm Workers of America, and that was ALRB admin orders number 2021-03 and 2021-06. In the other matter, Gerwin Farming, Inc., there were 2 admin orders, 2021-04 and 2021-05. Currently, there are no cases that are pending before the board, either for a decision or an action. That concludes my report. I'm happy to answer any questions.
Thank you, Santiago. Are there any questions for my colleagues? All right, thank you. Okay, next is agenda item number 5, the litigation report from Mr. Todd Ratchen. Todd?
Yes, good morning. Thank you. I have submitted a report to the board that is available on the board's website, providing updates in litigation matters since the last public meeting on February 9th. The most notable event to report on is in the United States Supreme Court case, Cedar Point Nursery versus Hasid. It's case number 20-107. The court heard oral arguments on March 22nd, and the case is now submitted and pending issuance of an opinion, which There is no real time frame in which to expect that, other than the court generally issues its opinions by the end of its term, which would be the end of June. So I think June is a likely time frame to expect an opinion from the court in that matter. For any interested parties or persons, the audio of the arguments and the transcript are available on the United States Supreme Court's website at supremecourt.gov. There is a drop-down menu for oral arguments where you can locate those items.
Thank you, Todd. Do any of my colleagues have any questions for Todd? And I want to say, especially acknowledge all of your hard work in supporting the board. We are represented by the California Solicitor General's office in the Cedar Point case, but Todd and our other board counsel played a critical role in ensuring that we were represented well, and just want to acknowledge all of your hard work. Next, we have the next agenda item is the General Counsel's report from General Counsel Julie Montgomery. Julie?
Good morning, Chair Hasid and board members and everyone who's here. I'm Julie Montgomery. I'm the General Counsel with the ALRB. And of course, the General Counsel program is comprised of the staff in the regional offices throughout various rural areas in California where agricultural workers are present. And they have been very busy. Our staff has been very busy in conducting outreach to farm workers to make sure that we can give them information about their rights, not only under the Agricultural Labor Relations Act, but also just information about how to protect themselves against COVID-19 and what steps they can take at the workplace to protect themselves, and just really, and also we're collaborating with a number of other organizations and agencies to make sure that we are having an impact in getting that information out to these vulnerable communities who are most adversely affected by COVID-19, or among the most adversely affected, I'll say. So we have an outreach team of 3 full-time dedicated staff members who have been working not only on doing the outreach themselves, but on creating content, presentations. We're doing a lot of presentations via Facebook Live. We've also conducted presentations to various nonprofits in different areas, and webinars to let them know who we are, what we do, what are workers' rights under the Agricultural Labor Relations Act, how can they help, how can we coordinate, how can they get workers to us, and how can we work together better to provide services to people. And we've, since the last board meeting, like I said, we've done several Facebook Live events, including partnering with Radio Indígena and different nonprofit organizations, which is a way for us to get more viewers through their connections and contacts. We also had a radio appearance on Radio Láser in Spanish, which was broadcast widely. We conducted trainings to 4 different nonprofits. We talked about how to collaborate. And then we've also been attending in-person events, including vaccine events, farm workers, food distributions, and other events. For example, today we have staff attending an event put on by Listos through the Office of Emergency Services, or the California Office of Emergency Services. They're putting on in early March, which is a emergency preparedness and personal protective equipment distribution event. We've also been present at a Lenore food distribution and the vaccine clinics in Fresno, Selma, and in Monterey County. So we've been attending a number of vaccine events. And as Chair Hasid mentioned, we also were at an event in Delano at the 40 Acres Ranch on Cesar Chavez Day, where hundreds of farm workers were being vaccinated. So we're seeking to get the word out. We're also working together with different partners to revise our materials and content, as well as a trifold brochure that we have about workers' rights and COVID related information and resources. We're seeking to make that as worker friendly as possible, regardless of literacy level, so that people don't have to have a minimum literacy level or a higher education level to understand the materials that we're distributing. So those efforts are underway. We estimate we've distributed approximately 5,000 of these flyers in the past month or so, and so those efforts are ongoing. And I also, Chair Seed also mentioned that I'm going to address some of the work we're doing in investigating some COVID-related charges. We do, at the ALRB General Counsel Program, we do have what we've identified as 9 charges that somehow relate to issues regarding COVID, and those charges are pending in investigation. And so we have 8 of those charges are out of our Salinas region, which covers, from basically the western half of the state, west of I-5. And then we have only 1 in the Visalia region, unfortunately. We've only received 1 such charge in that region, but we are investigating those charges, and they range from a variety of issues, including, just these are allegations from the charges themselves. Of course, we haven't made a determination about the merits yet, but we have charges alleging things from workers were terminated after complaining about working conditions, including handled treatment of workers during the COVID-19 pandemic. That's from one charge. Another one relates to workers complaining about the way in which their company was addressing COVID-19 and lack of precautions taken. There is another case we have where a group of workers complained to HR about a supervisor's treatment of workers, including that a supervisor was divulging information, confidential medical information about who had COVID-19, in violation of various laws. And we also have another charge where a charging party alleges he requested on behalf of himself and his crew members that the company provide COVID-19 testing after they learned that they had been exposed to some crew members who tested positive. And he alleges that he was terminated in retaliation for those complaints. So these are just some of the charges we're investigating. And like I said, our regional directors have previously provided a report on these charges, and they are still in investigation. So in addition, in my report, I like to talk about some of the settlements that we've reached, which our executive secretary has mentioned. We settled C&G Farms, which involved 9 farm workers weeding and thinning broccoli, cauliflower, and cabbage in Salinas. And they allege they were unlawfully fired after engaging in a walkout to protest a new attendance policy and the suspension of a forewoman. We did conclude a violation had occurred. We filed a complaint. There was a hearing set in early March, but we settled the case shortly before hearing. And we received all the standard remedies under the ALRB, including an agreement to respect the rights of workers and not retaliate, for the company to compensate. It was 9 employees for their economic losses, which they were paid $16,401. And we do not, we don't substantially compensate. We don't substantially compromise on economic losses when we settle cases. We do recoup, the amounts that are actually owed to the workers. Just if one was unclear on that. And we're also conducting a reading to the weeding and thinning crews during peak season in that case, of course. And we also settled a case pre-complaint against Gourmet Specialties and Ojai Farms in Ventura County, where a farm worker who was harvesting row crops in greens alleged in a charge that her foreman and supervisors intimidated and harassed her and several coworkers after voicing concerns that their foreman had mistreated them, and also that they were prohibited. Their foreman had prohibited them from speaking Purépecha, their native language, at the workplace. And we did, again, enter an informal bilateral settlement agreement in late March in that case, and the companies agreed to respect the workers' rights, not interfere with their rights, and to allow ALRB agents to conduct reading and noticing to the workers, together with interpreters in Spanish and Purépecha, which the employer will pay for. And they've also agreed to a 1-hour training for their supervisory employees regarding the provisions of the Agricultural Labor Relations Act and their responsibilities. We also settled a case against Santa Rosa Berry that was filed by a strawberry harvester in Oxnard, alleging that the company terminated her employment after she spoke up on behalf of her crew about working conditions, which included being provided with knives that were too dull, and also the mistreatment of crew members. And we did determine a violation was committed in that case, and we filed a complaint. A hearing was initially set for later this month, but we did reach a settlement with the parties last week, and the company agreed to, again, respect the rights of his employees, not interfere with their exercise of their rights, and they're going to pay back pay to the worker in the amount of $8,876, and we'll do the standard reading and noticing remedies as well. We also settled a case against Man Packing, in which a broccoli harvester in Salinas filed a charge. It was against Dominguez Farms and Man Packing, alleging that he and 5 other workers were transferred to a crew in which they earned less money in retaliation for engaging in a walkout after repeatedly requesting a piece of harvesting equipment, and they didn't receive a response. And we also filed a complaint in that case after determining a violation had been committed, and we had a hearing set for March 29th, but we entered into a settlement agreement shortly before hearing, and the respondents agreed to pay the workers $26,531 for their economic losses, and we'll get the standard reading and noticing remedies. And then finally, we recently settled a case out of Visalia region against Anthony Vineyards, in which a table grape harvester in Kern County alleged that the company retaliated against him and a coworker because they requested wages for reporting in standby time and for participating in union activity. And that settlement includes over $11,000 for the worker in back and front pay, and the usual ALRB remedies, and reading to workers during peak season, posting of noticing at the workplace. And we also were able to, the company agreed to have our staff come in and train their supervisors on their responsibilities under the Agricultural Labor Relations Act. So those are the settlements we've achieved since the last board meeting. And then I'll just conclude my report with just an announcement that we still have some available open positions in the General Counsel program. We have several attorney positions available, so please spread the word. They're posted on our website. We have some higher level attorney positions out of our headquarters, which can be based anywhere in the state, as well as some regional office attorney positions in our regional offices. So please check those out and spread the word for anyone who's interested. And with that, I'll just take any questions if there are any.
Thank you, General Counsel Montgomery. I don't have any questions, but thank you to you and all your staff's hard work. Always exciting to kind of see all the results that you're achieving out there in the field. Do any of my colleagues have any questions? Okay, thank you. Next is agenda item number 7, which is the Division of Administration Services report with our Chief Administration, Brian Doherty. Brian.
Good morning. I'm Brian Doherty, Chief of the Administrative Services Division. I have just a very brief update today. As part of the report, I did provide the latest expenditures for the ALRB that cover the period of January 1st, 2020 through February 2021, our most current expenditure month that we have available. Of our $11.8 million budget, we currently have a balance of approximately $4.4 million, which represents about 38% of our overall budget. So we are on target to stay within our appropriation authority for the remainder of the fiscal year. In addition to the expenditures, the only additional updates I have is given kind of the impacts of COVID, we have been seeing a lot of administrative audits and functions that are beginning to resume on a statewide basis. We currently have 3 separate audits that we are working with control agencies on. One of those is our working with the State Personnel Board to ensure that we're following all the policies and procedures as it relates to the HR functions for ALRB. We are engaged with the Department of General Services, who's reviewing our procurements that were concluded between the periods of January 2020 and March 2021. So they'll be reviewing all of our procurement files to ensure we followed all the state contracting policies and procedures as it relates to those procurements that were conducted during that time period. And then lastly, we will be working closely with the Department of Military, who's scheduled to come in and do a security assessment of our IT infrastructure. And that assessment is going to occur over a 3-day period between April 26th and April 29th. So as all 3 of these audits conclude and we get a draft audit report language, I'll be sure to share that out with all the board members and staff to ensure they're aware of any actions or corrective actions that need to be taken as part of the Administrative Services Division for ALRB. With that, I'm happy to answer any questions that may be applicable.
Thank you, Brian, and thanks to you and your team who kind of kept us going throughout what's been an unprecedented year. You guys are a small but mighty group, and just really appreciate all of your hard work. Do any of my colleagues have any questions? Okay, thank you, Brian. Next is agenda item number 8, which is the regulations report. Board Member Broad, I understand you will be sharing a report from the Regulations Subcommittee.
Good morning, everyone. So the Regulations Subcommittee, which is composed of myself and Member Lightstone, at the board's direction, undertook a informal review process in which we received input from the public. We had a workshop that was open to the public or for the public, and we met internally with staff and came up with a list of potential areas for updating and and changing some of our regulations. The report that you have in front of you basically lists the suggested areas, and it's divided into categories that kind of roughly follow our process through. And it encompasses really pretty much everything. In other words, it's a renewed look at our whole regulatory structure, particularly to update it for technical things like eliminating references to telegrams and technology that is no longer used, and otherwise streamlining the process. And then it includes some substantive suggestions as well. We stayed away from one area, which is the area of access, because that's the subject of a case at the U.S. Supreme Court, a decision in which could require us to do a separate, maybe regulatory package just on the area of access, depending on what the court majority determines. So we sort of stayed away from that. And we generally, there's also a bill pending in the legislature that would create a new process for workers seeking union representation that would involve a kind of kind of remote voting, a vote by mail type of arrangement, in which what would essentially be ballots would be collected and submitted to the board. So I won't go through all of these individually, but Ralph and I are certainly prepared to answer questions about any of them individually. Keep in mind, this is an informal process. We haven't entered the formal process of rulemaking, but our request of the subcommittee is that the full board at this meeting direct us to begin the process of actually developing regulations based on these suggestions. Some of these suggestions, when you get down to drafting, may be difficult and not viable, who knows? But in any case, that what we would bring back would be proposed regulations actually drafted, that the board could then decide to put out or not put out, and that could be with each regulation, for public comment and consideration in a formal rulemaking process. So with that, I will stop, and we're obviously, available to answer any questions about these proposals, keeping in mind that they're general. We haven't supplied specific language, nor has it been developed at this point. So that's it.
Thank you, Board Member Broad and Board Member Lightstone, for all of your work and for soliciting input from the public. I appreciate that. I did have 2 comments and 1 question, if I may, before opening it up to my other colleagues. One, I really, as I was reviewing these, I think just generally, it's very comprehensive and I think addresses a lot of issues that some of which I didn't even know existed, that could come up and will hopefully make our processes more efficient and solve any loopholes. 2 stood out to me as just critical for ensuring that the charges are able to be appropriately prosecuted and reviewed. One is the proposal that would allow a charging party the option to request that the general counsel protect their identity from disclosure during an investigation. There's an analogous process under the Labor Commissioner's retaliation complaint process, and I believe a somewhat similar process to some extent under Cal OSHA's investigative processes that I think is just really critical to ensure that workers feel safe coming forward and that these issues actually do get addressed, and so that their rights are not chilled or frustrated because of fear. And there may be some language in the labor code, specifically with the retaliation complaint process, that could be useful for as a basis for regulatory drafting. The other, I know you had mentioned this in a concurrence earlier or at the end of last year, but the procedure to require a time limit on when the general counsel can file a complaint, I think is also important. I also appreciate that there is an extension of time for just cause so that delaying tactics do not frustrate the general counsel's efforts at justice. So I think that's a really key provision that that stays with that. One that I had a question on, because I just am not as aware of the genesis, was the one that allows the general counsel to review dismissal of a charge by the regional director. I don't know if you can give any more background on that particular one.
Yeah, there's sort of a, and I think this is somewhat based on the way the NLRA is structured, or the way the NLRB is structured with its regional directors and its general counsel and the interplay between the two of them. But the current system allows regional directors to dismiss charges independently of any input from the general counsel herself. And it can be appealed, I believe, but I think that the idea would be that the general counsel would be able to review and make decisions about whether to ultimately dismiss that charge or not, because the statute clearly leaves the general counsel with the essentially sole discretion about whether to proceed or not to proceed with charges that are filed and issue a complaint. So that's the basic idea there.
Okay, great. Opening up to my colleagues, does anyone else have any other questions or comments?
No, I just want to thank both Ralph and Barry for a great job. I just want to acknowledge the hard work and efforts that they both put into this, long overdue. And so I just want to say thank you for the great work.
Great.
So I guess the question would be, what we would be requesting is that there be a motion to direct us to pursue this regulatory package and come back essentially with a developed set of potential regulations for the board to consider.
I'll move that as stated.
Thank you, Member Hall. Thank you, Member Flores. All those in favor say aye.
Aye.
Thank you. Look forward to seeing how this develops, and again, really appreciate all of your hard work. Okay, the next item, I believe, is agenda item number 9, which is our legislative report. Mr. Ratchin, can you provide our legislative report?
Yes, thank you. I provided a written report to the board, which I see there is a link on our website to the report, but unfortunately there seems to be an error with the link. But just a short update since the last meeting. There is a bill proposing to amend the Agricultural Labor Relations Act. It is Assembly Bill number 616. It was introduced on February 12th, and it is set for hearing in the Assembly Labor and Employment Committee on April 22nd at 10:30 a.m. I hope to get the link on the website operable. On the California Legislature website, there is a link that you can access the full text of the bill and information regarding it. And then at the Assembly Labor Committee page, there's information, the agenda for the hearing, and also a link to be able to view or listen to the hearing when it happens on April 22nd. But this bill would introduce a representation ballot card election option for agricultural employees to select a bargaining representative under the ALRA, which would be codified in proposed new labor code section 1156.35. The bill also proposes to add a new labor code section 1162, which would require employers to post an appeal bond as a condition of seeking judicial review of board orders providing monetary remedies to agricultural employees or labor organizations.
Great. Thank you, Todd. Do any of my colleagues have any questions? Okay, thank you. Moving on to agenda item number 10 is the personnel report. The board has no personnel items to report at this time. So I'll move on to agenda item 11, which is public comment. And this will be on the business portion of the meeting. You comment on any portion of the meeting at this point. There will also be an opportunity for public comment at the end of our informational panel. Please be advised that the board is unable to adjudicate, comment, or resolve any pending case matters before the board. I will ask our executive secretary, Santiago Avila Gomez, to go first through the queue and then open it up to others. If you have technical difficulties or miss your turn, we will work to come back to you. Please remember to be on mute unless you are speaking. If you require translation, please advise us. And I will ask the interpreter if you can share that advisory. Okay. Santiago, do we have any members of the public in the queue for public comment?
There is no one pending in the queue at this time.
Okay, any others that would like to make public comment at this time? Okay, and so with that, we will now take a brief recess for approximately 10 minutes. So it's 10:48 right now. I think we can safely say, let's come back at 11. So it'll be about, actually now it's 10:49, it'll be an 11-minute recess. And we will then have our informational panel, which I'm very excited about, on the H-2A program and contemporary issues. So we'll break for 10 minutes or so and come back at 11 a.m. for our informational panel. Thank you. Get water and a snack.
Keep that blood sugar going.
Hey, Santiago, are you on the line?
All right, checking out the makeshift timer.
Oh, okay.
Oh, we're hot mic.
Can you hear us? Okay.
Yeah, I can. Oh, this doesn't have a mute. Whatever. Clock stopped moving.
Oh, that clock, yeah.
Weird. Maybe my computer slept.
Okay, good morning. Santiago, just checking, is our audio still okay?
It is, I can hear you.
Okay, great. Welcome back, everyone. Thank you. We will now have our informational panel, which is an overview of the H-2A worker visa program and contemporary issues. I am so pleased that the group of panelists that we have here today were able to join us. They are all incredibly busy, and I just want to acknowledge my appreciation for generously donating their time to provide this panel. I'm very excited. I'll be going over briefly who will be joining us today. We do have some additions that I want to just let everyone know about, and then we will dive right in. So I know on the agenda, we had listed Mr. Michael Eastwood from the U.S. Department of Labor. He is unable to join us today. I understand, thankfully, though, Richard Longo from U.S. Department of Labor, good to see you, will be able to join us. He will be joined by Ruben Lugo, who's the Regional Agriculture / H2A Coordinator for the Western Region of USDOL Wage and Hour Division. We will also have Roman Diaz, the H2A Program Manager from the Employment Development Department, also known as EDD, as well as Cornelio Gomez, the Group Manager for the Foreign Labor and Farm Worker Services Program, again with EDD, joined by Cynthia Rice, the Director of Litigation from California Rural Legal Assistance, otherwise known as CRLA, good to see you. And then Jean Malitz, President of Malitz Law, Inc., will also be joining us. So with that, we will dive right in. First, I believe we'll have Mr. Roman Diaz and Mr. Cornelio Gomez with the Employment Development Department to present on the state of California's role with the H2A program. And with that, I'll turn it over to Cornelio and Roman.
Thank you for that introduction. My name is Cornelio Gomez, and I'm the manager that oversees the H2A program with the Employment Development Department under the Workforce Services branch. The H2A temporary agricultural program allows agricultural employers who anticipate a shortage of domestic workers to basically bring in non-immigrant foreign workers to the U.S. to perform agricultural labor and services of a temporary, I want to underline temporary and seasonal nature. However, the department must determine that there's two conditions, first of all. There are not sufficient able, willing, and qualified U.S. workers available to perform the temporary seasonal agricultural employment for which non-immigrant foreign workers are being requested. And number two, employment of the H2A workers will not adversely affect the wage and working conditions of similarly employed U.S. workers. Generally, this program allows the employer to bring in workers anywhere from 2 to about 10 months. What I want to do before I introduce Roman to provide you an overview of the H2A process and our roles and responsibilities, I want to touch for a minute or two on the demand of the H2A program, okay? If we look back at year 2010, we had about 2,577 basically job opening workers in the H2A program. In 2015, that increased to about 10,074. And in 2020, we're up to 25,453. And it appears that the demand continues to increase. If we compare, 1920 to 1819 years, there's still about 9.1% increase in workers, temporary foreign ag workers coming into the state. Just briefly, which counties basically have the most demand? We're looking at Monterey County's the number one, no surprise there, followed by Santa Barbara, and then Imperial County, then Ventura. If you notice, and San Luis Obispo. Those are the top five. If you notice real close, Santa Barbara and Ventura and San Luis Obispo, they're real close together there. But what I'm seeing an increase or a trend in new demand is basically in Fresno and Sonoma counties. As we're processing the job order, right, and identifying some of the requirements that employer needs to abide by. One of the delays that we're seeing in the H2A program is housing. There's anywhere from, in any particular month, there's anywhere from 25 plus applications that get delayed because some employers are scrambling around to get additional housing due to the emergency temporary standards, I think of 3205.3, that requires 6 feet, distancing between the workers. With that, let me turn it over to Roman. And like I said, he'll provide a high-level overview of the role and responsibilities here. And we're sharing here the hot mic, so.
Good morning. My name again is Roman Diaz. I also go by Roman. And yes, so, you probably have the H2A application process flow chart, the timeline there for you. I am also in this group that Cornelia mentioned, the Farm Worker Services and Foreign Labor Certification Group in central office here in downtown Sacramento. With the Employment Development Department. I have 6 analysts right now assisting me to make sure we administer, manage the H2A program in conjunction with the Department of Labor. Our purpose is very, very specific, very different than the federal government. At the state level, we're pretty much required to, what Cornelia was mentioning earlier, there's 2 conditions: that there's not enough workers in the United States. Employers must demonstrate that, and that the fact that they're going to be bringing any foreign workers will not adversely affect the wages and conditions of employees. So to that end, what we do is we review applications that are submitted to us. The employers, this is the first stop for the employers in terms of the state. They will submit the H2A application, which is basically the job order, also known as the ETA 790A. And that's a federal form that contains all the terms and conditions of employment. So once we get the application, 75 to 60 days before the start date, and those timelines are pretty strict. The employer must abide by all these timelines. Then we will start reviewing the application to make sure that it complies with all the local, state, federal labor-related laws, and that there's nothing there restrictive for the U.S. workers. You can picture our work mainly consisting primarily of testing the labor market, right? So when we review these H2 applications, we want to make sure that they contain information there that's not going to restrict U.S. workers, because we will be, as soon as we accept the application, and we have 7 days to either deny or have the employer modify or correct anything on that application regarding the terms and conditions of employment. We have 7 days to make sure we do that. If it is accepted, we will enter a job order in our labor exchange system, also known as CalJobs. And this is it's a recruitment effort that begins at that point. And we have all our field offices throughout the state. We announce it to them, making sure that they're going to begin actively recruiting U.S. workers to place in these H2A job vacancies, job orders. So that's one of the efforts. Another, at that same time, 75 to 60 days before that, we need to ensure that the employer has adequate housing. So we have 5 housing inspectors currently right now, full-time in the field, conducting those inspections. And also another agency in the state, which is Housing Community Development Department, is also part of this effort of conducting inspections. But regardless of who conducts the inspection, The employer must have adequate housing that meets all the, applicable standards, local, state, and federal. And they have to have that ready 32 days before the start date. So our inspectors are actively making sure that we have meet that requirement for the employer. So that's how we assist in that sense. So it's really making sure that the employer has everything in order, that the job order that's listed in our labor exchange system does not contain anything that's going to preclude U.S. workers from applying, that the employer is going to provide housing at no cost to the employees, that the wages that are going to be paid are going to be the correct wages, that transportation is going to be provided under certain conditions, and that meals will be provided, et cetera, et cetera. And I'm pretty sure Ruben will probably cover a little bit more on all these requirements that they enforce, which they enforce on. So as we move closer to that 45-day before the start date, we want to wrap things up and make sure that our recruitment is undergoing at this time. It actually continues, our recruitment efforts in the field continue through 50% of the employment contract. And Cornelia was saying that some of these contracts can last up to 10 months. So the job order stays open through 50% of that contract. 45 days before the start date, and by this time, we would have already cleared everything with the employer, any deficiencies, incomplete items. The housing inspection could have been already completed, but it is required to be completed by 32 days before the start date. But 45 days before the start date, the employer is then required to submit the application 45 days before the start date to the Department of Labor. And that's also a federal form that they submit to the Department of Labor in Chicago, known as the Form 9142A. And this form, as well as the ETA 798 that I mentioned earlier, requires the employer, and it makes it very clear that they must abide by all the local, state, and federal labor-related laws and regulations, standards that apply. So, and now the Department of Labor has a automated system. It's a portal known as FLAG, which stands for Foreign Labor Application Gateway System, which started about almost a year ago, I believe, not too long ago. But I think it was a great improvement because whereas before, employers could submit an application that was missing a lot of items, and they were able to do that. But with this new process that the DOL has in place, the application has to be complete. It won't let it move forward if it's not complete. And it also embeds information on the assurances that the employer must comply with, and also makes it very clear before they sign that they have signed knowing that they must abide by all the applicable laws, regulations, and standards. So 45 days before the start date, they submit the 9142A, also attesting all these things. 32 days before the start date, by this time, we would have had to conducted the inspection or verified that the employer has the housing facilities in order, that they meet applicable standards, local, state, and federal. And then we would report the results or the findings to the Department of Labor, known as they're based in Chicago, the Chicago National Processing Center is who they are, but it is the Department of Labor. So we would notify them that the housing and the application is in compliance, and that the employer will now apply with them to get the certification of the number of workers that they are requesting. So we recruit U.S. workers. The Department of Labor is the one that's going to be in charge of certifying certifying the number of workers to bring in, meaning they'll give the green light to the employer to bring in the total number of workers, or the total number of workers minus the ones that EDD recruited for the employer. And just wanted to point out that, you know, our recruitment, as you can see that orange line that just continues, is because we do continue recruiting efforts through 50% of the employment contract. So basically, in a nutshell, these are the process that we have in place here at central office in my unit. Thank you.
Thank you so much. Is it okay to open it up for some questions?
Sure.
Both of you? Okay, great. One question I had, I'm kind of thinking of the other side of your house that deals with unemployment. How do employers demonstrate that they are having trouble recruiting workers in state?
That's the whole purpose for us. The employers, by the time they submit the H-2 application with us, they should have already conducted their own efforts, their own recruitment efforts, and by submitting the application, they're basically stating that there are no U.S. workers, that there is a labor shortage in their respective areas where they're applying. And so that's how they will let us know that this is why we're submitting an application. But that's why we're going to be looking at that. And that's the test of the labor market, by making those recruitment efforts and opening that job order and conducting recruitment through 50% of the contract. Keep in mind that if the employer brings in whatever number of workers, if they're certified by whatever number of workers that are foreign workers, and they start working, U.S. workers have a chance to still be hired if we find workers interested in that position, all the way through 50%. So the employer will have to either, add positions, or in extreme cases, probably maybe return the foreign workers so that the U.S. worker has a chance to be employed. I'm not sure if that was answered your question, or you needed.
No, that's very helpful. It's very helpful. I have a couple other questions, but I want to share the floor with my colleagues. Do any of my fellow board members have any questions? Board Member Broad?
Yeah, you mentioned at the beginning kind of the geographically specific information about kind of which counties the H-2A program for agriculture is concentrated in. Is it concentrated in particular crops some crops as opposed to other crops? Is there a reason for that in the general sense?
Yeah, and for the most part, the majority of, and I wish we had a map because it really shows the counties that have most of these H-2A workers in. But the Central Coast, the Southern Coast, some up north, but mainly in the coastal areas is where most of these jobs are concentrated, and primarily for strawberry, lettuce, tomato, vineyard workers, and those would probably be the top 5.
Thank you.
Great. And I think I saw Member Lightstone, yes?
Yeah, I just had a couple of questions. Thank you for the presentation. I'm trying to understand in this process that you described, the DOL processing, EDD doing what it's doing in relation to our processes. So does the process, if the applicant had a notice of access pending by a union, or if they had an election pending under our processes, or if there was a charge or a complaint issued, would any of that be acknowledged in this review by DOL?
Yeah, the regulations do say something about that. The employer, cannot be recruiting foreign workers if there's any labor union disputes ongoing. So that, yeah, that is in place under the regulations.
Okay, thank you.
You're welcome.
Member Flores?
Hi, thank you for the presentation. I had two related questions, I think. And you mentioned, there's been almost a 10 times increase in the amount or demand of H-2A workers in the last 10 years. Is there a reason for that? There's been such an increase in demand for H-2A workers, and relatedly, is there any particular reason why there's been an increase in demand in Fresno and Sonoma County recently?
There's other, I will say, based on what I've seen and I've heard from other experts, the labor shortages is due to a number of factors. One of them being that the next generations of foreign workers that come in here and stay, their children are not going into farm work. They're going into, they go to college and they graduate and they don't want to work in the fields. So the new generations aren't, the employers can't pull from that source. That's one. And those that do are still engaged in agriculture are retiring. They're elderly that are retired. So that also creates that vacuum, that shortage of workers. And also, of course, California being, one of the best places for agriculture. And the employers is the only means that they have to bring in foreign workers, a legal means. The borders crossing, that also at times, depending on which administration's in place, plays a role as well. Sometimes it's easier to come in, and other times it's not. But I would think that the employers, for the most part, are not finding any new workers. And I want to say that the reason is because those new generation of workers, they're not interested in agricultural work.
Interesting. Thank you.
But there could be a lot of other factors. You want to chime in on any of that?
Yeah, let me just do this. Let me just pull it over here. We're kind of sharing this. In addition to, the reasons that Ramon mentioned, one obvious one, first of all, I want to clarify one thing a little bit here. The H-2A program is just for workers who are legal here in the state. Okay, so we have about 55% of the 800,000 ag workers that aren't able to utilize the program. So why are employers utilizing the program is because the about 40% of the total workers is about, they're seasonally employed, correct? So they work 6 or 8 or 9 months out of the year. In addition to that, it's basically the low pay, right? We get some fast food services that are paying a little bit more than the minimum wage, right, for ag workers, and it's not as laborious. So it's also the pay. For those seasonal workers that are legal here to work, they're not going to leave their employer that they had for the last 20 30 years, to apply for a program that requires them to work anywhere from 2 to 10 months. And generally, and instead of, working on a seasonal basis. So there's different pull factors there. And I'll leave it there. we leave them up forever, but I'm looking at the time here too.
If I can ask just one last question, just out of curiosity, I was wondering how often are employer job orders not approved, and what is the primary reason for not approving job orders?
Let me kick that back over to Roman. You have a.
Yeah, and well, there's a couple things. Not approving is one thing, and reducing the number of workers that the employers request is another thing, because that's based on the recruitment efforts that we conduct. If we place U.S. workers, then the application continues because it's not fully supplied. In other words, let's say that we recruit 10 out of 50 that the employers requested. The Department of Labor would have our recruitment report by then, by the time the employer applies, and they would reduce that number from the 50. The other thing is that, in this process, the employers are given an opportunity to modify their application. So if they have there something that we would say, if your requirements are restrictive or they're outside of the law, you either need to remove them or you need to justify why you're requiring this job, the workers to do certain things in this particular job. So by the time that the employer submits the application, they know that we're going to be working with them to correct those deficiencies. If they don't correct the deficiencies, or it's really they're just not cooperating with us, and it's an obvious violation of the laws, we do have that option of denying the application. But for the most part, we work with them to correct those deficiencies.
So how was denial rate? About 5%.
About 5% of them that are denied. Yeah.
Thank you.
You're welcome.
Any other questions from my fellow board members? Okay, thank you so much, Cornelia and Roman. I do hope you can stay through the end. We can open it up to some broader questions. I have a couple, but I want to be respectful of everyone's valuable time. So we'll move on to the next presenter, but really very interesting overview of the program.
Thank you.
I'll next turn it over to Richard Longo and Ruben Lugo with the U.S. Department of Labor Wage and Hour Division. I'll also ask, if you're not speaking, just a friendly reminder to please go on mute, just so we have good audio quality and we can hear the presenters.
Okay, good morning, everyone. So my name is Richard Longo, and I'm the Deputy Regional Administrator with the Wage and Hour Division here in the Western Region. And I used to do a lot more agricultural work, and when I was Director of Enforcement, Ruben and I still tag team a lot on some significant events across the region, but we're responsible for the enforcement and education of over 40 rules, regulations, and statutes, one of which is the H-2A program. And from our standpoint, we believe a lot heavily in the two components. Education is very important, whether it's to employers, employees, or to advocates. And it's also very important for us to do enforcement. And it's one is equally important as the other. And we do make a lot of efforts to reach out when, for example, when we saw the strawberry industry gaining momentum in the H-2A program, Ruben and I kind of went around the state and did a number of events to kind of educate the strawberry growers. And we feel like they kind of jumped in, not making the mistakes that a lot of others do. And one of the things that we realize in the H-2A program is when you bring in lots of workers, if you make a mistake, it's quite costly, because you replicate that times hundreds of workers, And when people get involved in the H-2A program, they usually make a lot of mistakes because what might seem to be common business sense sometimes goes against what the regulations tell you to do. But with that being said, you know, we always want to offer that. And Ruben is very well accomplished in keeping connections across the state and across the region to do these education and outreach events. We believe reaching down at all different layers and levels to make sure that the community is well informed. And he's not going to have a lot of time to get into details today, but I think he's going to highlight some of the things that concern us the most. And I thought I heard Cornelio say that Santa Maria, Oxnard, Fresno, Sonoma counties, we're seeing increases in the H-2A program. We're seeing issues as well. And one of the big issues that we have, like for instance, in Sonoma County, is that a lot of the workforce comes from the Fresno area and they're traveling significant distances on a daily basis because of the lack of housing. And it creates a lot of issues with unsafe transportation. I think you heard already from Cornelia and Roman about the shortage of housing. That is a major concern for us. We find a lot of overcrowded housing or in substandard housing, and sometimes really egregious situations with people living not even within structures. And that's alarming for us. And also in the transportation front, we did have a significant case a number of years ago called Valley Garlic. And it basically just said, as an agricultural employer, you just can't turn a blind eye to the fact that you're causing transportation to be used. Because under the regulations, it's not just direct transportation, but it's also causing transportation to be used. And because there's lack of housing where a lot of the farming areas are, whenever a farm labor contractor or H-2A labor contractor brings a large crew of workers, they're likely transporting. These workers don't get to the fields by themselves. And under H-2A, it's a requirement to provide transportation, and it has to be safe and it has to be insured. So there are just a number of things that we continue to come across and have to address. And then the use of H-2A labor contractors or farm labor contractors that are just moving their workforces around outside the area of intended employment. Another big concern for us. And probably the last high level concern that I have before I turn it over to Ruben is just the recruitment of the US workers. And we had a large case not too long ago, Munger Farms, and that case involved a significant number of workers, even from the prior season, that were not contacted. And we've seen throughout just a higher use of the H-2A program, primarily because they're a captive workforce and they're reliable, more reliable. And then just to want to add a little bit to the question that was asked a little bit earlier about why we're seeing less workers or less agricultural workers. Another thing that adds to this is that a lot of the agricultural workers have moved on, not just in fast food, but on the East Coast, it's very well documented, and it's probably prevalent here as well, that a lot of the workforce has moved into landscaping and construction because it's more stable. You don't have to go from farm to farm to farm and state to state to state, and the pay is a lot higher. So with that being said, I'll turn it over to Ruben because he's got some really good stuff for us, and I want to make sure he has time to get to it.
Good morning, everyone. Santiago, if you can put up our PowerPoint, that would be great.
Will do. Coming up.
Okay, I think Richard and Cornelio touched on a few things I was going to touch on, so I think I have a limited time. Victoria, how much time do I have left?
I think you have about a half hour, I think, and that'll still give us ample time to have our other presenters and room for discussion. So knock yourself out.
All right, so if you can go to the next slide, that'd be great. So you heard from EDD, and EDD is actually the first agency that gets involved with the H-2A process by testing the labor market, as Roman mentioned. But Department of Labor Wage and Hour is the agency that has the authority and jurisdiction to regulate the H2A program, ensure that those that are using the program are following all the rules and regulations. Santiago, can you go to the next one? As you can see on this slide, there are several government agencies. These are different agencies that are involved in the certification and visa process. So you can see EDD is the first stop. Then Department of Labor, Employment and Training Administration is our sister agency. They're the component of our agency that actually issues the certification. So EDD alone doesn't certify the H2A program. They pass on the information to ETA. ETA is the one that ultimately either approves or disapproves, although EDD can kick back applications that are not complete, or if they feel that they're lacking in different areas. Now, after they're certified, then the employers that are using H2A have to deal with the U.S. Customs and Immigration Service, USCIS. And they'll be the one approving if they're going to be issued the H2A visa. Once USCIS approves, then a meeting is set up with the consulate offices, the U.S. consulate office, and that's where potential foreign recruits would go and get their H2A visa. And for example, if we're talking about workers from Mexico wanting to come work in California, they would either go to the consulate in Monterrey, Mexico, Nogales, Tijuana, Hermosillo, and I believe there might be one or two other ones, but those are the primary ones. Once the worker gets their visa, then they still have to cross the border. The U.S. Border and Custom Patrol will vet those workers coming into the U.S. And ultimately either let them in or even deny access. So Department of Labor Wage and Hour, again, is the agency that is more of the enforcement part of the H2A program. However, USCIS, Homeland Security, they do have a fraud department. The U.S. consulate offices have an internal fraud mechanism as well. And Department of Justice, U.S. Department of Justice also looked into discrimination of U.S. workers that might be applying for these jobs and are being discriminated against. We can go to the next slide, please. So Cornelio talked about this, and the purpose of the H2A program is really to supplement the existing ag workforce. It's not to replace the existing U.S. workforce, it's to supplement only. So for an employer wanting to use the H2A program, they have to make an attestation, a declaration that they can't find enough sufficient workers who are able, willing, and qualified and are available at the time and location that they need them. So the time of need might be a few weeks, it might be a month, it might be 5 months, it might be 6 months, it might be in a certain geographic location, because perhaps the U.S. ag workforce in those areas prefer to do other types of crops that are paid at a higher rate. Perhaps some work is not as strenuous as others, and the H2A workers are filling in those gaps. Now, along with this protection of ag employers that are using the H2A, they have to hire all U.S. workers who are able, willing, and qualified. And the fact that these employers are using the H2A program should not have an adverse effect on the existing agricultural workforce. So it should not lessen their wages. It should not lessen their working conditions. And Santiago, I think we lost our PowerPoint. We can go to the next slide, please. So we have various categories, enforcement or requirements, and we have them in different categories. The first one I have listed on here, and to be honest with you all, we take 3 days to train our investigators in H2A compliance. When we do outreach to agricultural employers on H2A, we spend at least about 2 hours giving them the basics. So this morning we're going to spend perhaps 15 to 20 minutes going over different requirements that some of them are quite complicated. So we do have U.S. worker protection. So the basis of the H2A program primarily is to protect the existing ag workforce. So how does the law do that? Well, it requires that any U.S. worker that wants to apply for these H2A job opportunities, if they're able, willing, and qualified and available, then that H2A employer has to hire them. Okay, and all that is based on what's on the job order. In addition to that, this employer has to do local recruitment. It has to do interstate recruitment of workers, maybe perhaps from Arizona, Oregon, and Washington that might want to come to California and work. In addition to that, there could be ads or different mechanisms the employer might put out to recruit workers or walk-ins. That employer has to list all these people in a recruitment report and has to make documentation of what workers applied and why they weren't hired for these job openings. Additionally, an H2A employer has to recruit all workers from the previous season that did similar type work in the same location. So we mentioned the Munger farms. That was their error because they didn't contact all the blueberry workers from the previous season to see if they wanted to work picking blueberries for the season they put the job order. So they had to pay an enormous amount of money paying these workers for lost wages. So the penalties for not hiring a U.S. worker is one of our highest penalty that we have. Plus the employer is required to make these workers whole and pay them all the wages that they lost. So this is a very serious violation. A lot of our H2A employers that have been in the program are aware of this and do keep good records on the recruitment report of who's they've interviewed and who have, what workers have been referred by EDD as well. We also have unlawful termination. If a U.S. worker was unlawfully terminated, perhaps because the employer preferred H2A workers, that there's protection for those workers as well. So that's one category. Another category is disclosure. The employer is required to provide a copy of the contract to anyone who's applying, and whether that be a foreign worker or a U.S. domestic worker. We also have a ton of wage-related violations that might occur. I'm going to capture a few of the most common ones. We have paying the highest applicable wage rate. So a H2A worker or a U.S. worker that applies for an H2A job has to be paid no less than $16.05 an hour, much higher than the state minimum wage, as you can see. Or if the state minimum wage for some reason ever is higher than the AWR wage rate, then they have to pay the state minimum wage. Or if there is a collective bargaining agreement and there's a union shop and that is higher than the 1605, then that employer would have to pay that higher union wage. Okay. And lastly, there is prevailing wage rates. As you know, in the wine country, those workers over there up in Napa, Sonoma might be getting paid $18 an hour. The local workforce might be getting paid $18 an hour. Well, a grower in Sonoma or Napa would save a lot of money by hiring H2A workers, right, at $16.05 an hour. Well, that's why there is a mechanism here for EDD to conduct surveys to make sure that H2A employers are paying the prevailing wage if that is higher than the AWR wage rate, but they do have to go through the survey process. Now, some areas had kind of the COVID pay for agricultural workers. I think Coachella had an additional $2, right? So let's say the minimum wage for the state was 15, and let's say the Coachella had an additional $2, that would be $17 an hour. So we would take the position that that $17 an hour is the highest applicable wage rate, and we would ensure that they're paid that higher wage rate. There's also a provision in our regulations that H2A workers or U.S. workers that are covered by H2A contracts have to be paid at least 3/4 of the contract. We call that a 3/4 guarantee. And there's the H2A employer also is responsible to pay for the trip to get to the work site from their hometown. So let's say they're from Michoacan, Mexico, then they would have to pay their trip from Michoacan, let's say, to Stockton, California, if that's where the work's at. So they would have to pay their bus fare, any hotel stays for them to get the visa. There's a food subsistence, and if the workers finish the contract, then they have to get paid their return trip back. Okay, so you can see that the H2A program can be quite costly to an H2A employer. We also have a record-keeping provisions that the employer is obligated to keep. Santiago, if you can go to the next slide. So there's also high housing requirements. So all the H2A workers that are hired have to be provided with free housing, and the housing has to be inspected. So initially the housing inspected by EDD in the state of California. The Housing Community Development also does an inspection. They also provide a permit to operate. So as you can see, an H2A employer housing might be inspected a few times. If we initiate an investigation, then we're going to inspect it a third time. And I believe EDD does some courtesy inspections during the time that the workers are actually living in the housing. Okay, so the housing has to be maintained in a safe manner. It has to be kept in a clean manner during the occupancy. Also, U.S. workers that cannot return home have to be provided in a reasonable time, have to be provided with free housing as well. So it's not just the H2A worker. So let's say you have an employer in Bakersfield that put a job order for onions, and a group of workers from Stockton came and they applied, right? So the employer hired them. Since it's not reasonable to go back to Stockton every day after they work in Bakersfield, the employer would be obligated to provide those workers from Stockton housing, typically the same housing that they would be providing to the H2A worker, and that housing would be at no cost. Those workers that are being housed are going to be provided with kitchen facilities that are safe, that have stoves, have refrigerators, have cooking utensils. The H2A worker that are provided with kitchens, it's their responsibility to go to pay for their own food items, their groceries. But the housing that doesn't have kitchens, the employer is obligated to provide 3 meals per day. Okay. The employer is allowed to make a deduction for those meals. The allowable deduction is $13.17 an hour. And you're probably thinking, who can buy a meal for $13.17? I think that most of your lunches today cost more than $13.17. So it's understood that the employer is probably going to subsidize some of the meal cost. Okay, the employer can request a higher amount, and there's a process to do that. In addition to meals, we have a transportation obligation. We mentioned the trip in and the trip back, but there's also transportation from the housing to the work site. So all those workers that are staying in the employer provided housing have to provide free transportation from the housing to the work site and back in a safe manner. The transportation has to be safe. They have to have adequate insurance. The drivers have to be authorized and licensed to drive those vehicles. Now, local workers that might be covered by the contract that can go home every night are not provided or required to be provided transportation. It's understood that they will take their own vehicles since they're not provided with housing. Now, H-2A workers can decline the housing if they want to stay with a relative member. Let's say they have an aunt in Bakersfield, a tia, as they say in Spanish, in Bakersfield, and would prefer to stay with them. That H-2A worker can opt to do that. That H-2A worker can opt to take their own vehicle to the work site if they would like. However, the employer still has to have that transportation available to those workers. Next slide, Santiago, please. So this is my last slide. There are other legal requirements. The cost of the visa, the employer has to pay for that. Any cost associated with getting the job, obtaining the job, the only cost that an H-2A employee will have to pay for is the passport. Everything else, the employer will bear the cost of that. Now, the employer is required to have workers' compensation. The employer is responsible to ensure that whatever recruitment agencies they use are not asking for kickbacks, or in Spanish they call mordidas. And this is a very difficult. I think that this practice is going on. We believe that the H-2A workers that are coming in from Mexico are having to pay fees, extortion fees. We've heard from cartel organizations. And it's very difficult for a worker to come out and tell us that this is happening. The few times that we've been able to prove it, we've corrected this. We've gotten these workers reimbursed this money. However, it's very difficult, and this is an area I think that the U.S. needs to work with the foreign countries that provide H-2A workers on ensuring that H-2A workers in their home country are not taken advantage of. Okay. Here's another regulation: comply with all applicable state and federal regulations. So when we conduct an H-2A investigation, we're also ensuring that they're complying with all other regulations, whether that be state overtime in ag, the shade regulation, the COVID regulation that the state has passed, any type of state regulation that applies to ag apply to H-2A workers. I would imagine that would include anything the ALRB would be enforcing as well. H-2A, and I forgot to mention this in the beginning, that there's only 3 types of entities that can apply for H-2A workers. One is what we call a fixed site employer. That would be typically your grower, your packing house, your nursery, anything that would be considered or defined as ag. The other is an ag association. Now, let me go back again to fixed site employer. When a fixed site employer or farm requests H-2A workers, They can only work those workers on their farm on fields that they listed on the job contract. So if we have a grower that has acreage in Kern County, and then they have acreage in San Joaquin County, they only asked to work those workers in Kern County. They cannot move those workers to San Joaquin County. Those workers can only work in Kern County on the acreage listed on the contract, okay? They can't loan the H-2A workers to other entities, to other farmers. Those workers are restricted to work only on the crops listed on the job contract and locations listed on the job contract. The association has a little bit more flexibility. Association is a group of growers, perhaps a co-op, and they apply as an association. They can move the workers between farms. All right, so they're applying as a group. Last is what we call the H-2A farm labor contractor. That would be a farm labor contractor. This is the area that's growing the most in California, is the H-2A-LC. The largest H-2A users are H-2A-LCs. They can list various growers on their contract and move them around within a certain geographic location. Richard mentioned intended place of employment. Usually that might be a metropolitan statistical area, a county area, a common commuting area that's common for workers to commute. So that gives the local workforce that doesn't want to travel 2 or 3 counties down an opportunity to work on these jobs, because the employer cannot say, hey, you're not willing to work at all my work location, so I'm not going to hire you. So this is actually a protection for the local workforce, in that these jobs are being announced within a local commuting area. We can go back to this slide. I think we lost it, and we have Victoria on my screen right now. Hi, Victoria. We have that farm labor contractor has to have a farm labor contractor license with the LLC, as well as with our department. They have to have a bond. They'll have a bond with the LLC, but they'll also have a bond with us. In case an FLC for some reason belly ups and owes workers money, we can attach the bond and pay the workers any money from these bonds. So I kind of gave you a 3-day overview of H-2A in about, what was that, 20 minutes? So I didn't go into details, and I probably left out a few other requirements, but I wanted to give you a overview of the requirements. You can see there's quite a bit of requirements. It's rare for us to do an H-2A investigation and not find a violation. However, I do have to say that we have seen among those H-2A employers that have been in business, or have been using the program for years, are most likely to be at a higher level of compliance. The businesses that we see have the most egregious and probably have the lowest level of compliance are those entering into the program maybe their first and second, maybe third year. Okay, employers that are not don't feel comfortable with the English language, we've seen notice that also have a higher tendency to be in violation. As such, we have been doing a lot of outreach to employers, Spanish-speaking employers. We've been doing we were doing 2 or 3 employer outreaches a year. We have worked with the Mexican consulate on educating H-2A workers. H-2A workers are very reluctant to file a complaint. The complaints that we do get from H-2A workers have been through EDD, outreach workers going out to the fields. We've actually gotten probably 2 leads from the ALRB, different offices that have turned out to be quite good cases for us. So thank you for those referrals, and we look forward to working with ALRB, and we like to continue educating both employers and H-2A workers. We want to encourage employers to be in compliance, but we also want to encourage employees to assert their rights if they feel that the employer is not following the rules and regulations. Thank you very much.
Thank you so much, Ruben and Richard. I'm going to open it up to our board members for questions. I have a few, but I'll open it up to my colleagues first to see if they have any questions for either of you. Board Member Brown?
How is their health care covered?
That's a good question. Well, the only healthcare coverage, and I think we have an employer representative on this panel and can probably talk a little bit more to that, varies on the employer. If the employer offers medical insurance, the H-2A worker is going to be offered health insurance. If the employer is offering health insurance to their regular workforce, most likely if the H-2A worker qualifies for it, they're going to offer it to them as well. But most H-2A workers probably decline any type of health coverage because they don't want to see that large deduction. Any work-related injuries, COVID, for instance, disease, COVID, any accidents should be covered by workers' comp. And employers are required to follow all the rules of following with workers' comp regulations. We would like to, we've had a few incidents where H-2A workers have died in their housing due to lack of medical attention. As you remember the case in the state of Washington, a worker died, was taken to the hospital. This H-2A worker had a pre-medical condition, didn't have access to his medications. His medicines ran out. We need to do, and I'm asking the stakeholders on this call, the farm worker advocacy groups, to really look at educating the H-2A workforce on what health clinics are available to agricultural workers. That's definitely an area that can be improved. There is already lots of clinics that target agricultural workers. The H-2A workers just are not familiar with the system. I know we've been encouraging H-2A employers to talk to them, to bring in the health clinics into the housing and talk to the workers. That way, if the workers need medication, they know where to get it. But these health clinics do charge a lower cost, and if H-2A workers would have access to that, I'm sure there would be a few workers that would still be alive today if they would have had access to medical care.
Thank you. Do any of my other colleagues, fellow board members have any questions? Cynthia.
Thank you so much for the presentation. I was just wondering, presentation focused on letting us know what the employer's obligations are to the H-2A worker. I had a question, and maybe this is a question that can be answered by the employer representative later, but what responsibility, if any, does the employer have to provide the worker themselves about their obligations to them? So okay. Is there like an onboarding process, education process? Because it seems like there's a lengthy list of obligations, and are the H-2A workers made aware of that? Or how are they?
All right, so in our regulations, there's two mechanisms to inform workers about their rights, okay? So one is the actual job contract. The job contract has a whole listing of what the employer is responsible to provide them with, right? And there's also, we have an H-2A poster. It's a green poster, and it'll list what all the employees' rights are. In addition to that, I believe EDD goes out and provides handbooks. Our outreach people provide different outreach material to the workers. And my understanding is our U.S. state consulates have a video that they show the H-2A workers before they come into the U.S., kind of going over all their rights that they have. Now, I would imagine that those rights are very generic and not specific to California. So again, if a collaboration of stakeholders and agencies can put together some kind of mechanism to give to workers on, where to go to in case this happens, if you get food poisoning, or if, what happens and under certain circumstances, because these folks are new to the US, they don't really understand what's going on here. Some of our employers that we have in some of the stakeholders actually do a very good job of onboarding. They teach the workers about all the local laws, so they don't have problems with the police force. They kind of try to get them to understand, how to go grocery shopping, how all that works, how banking works, so they can send money back home. Some employers do a very good job at that, and I would imagine that some don't do a very good job at all at that. But I'll defer to the employer representative if they maybe have some best practices that they're doing and that they're promoting amongst their membership as well.
Thank you. I have one question. Is the AEWR of 1605, is that specific to California or for all states?
No, each state has its own adverse effect wage rate, and it varies.
Okay.
Like Arizona is possibly $2 and something cents less than California. Washington, Oregon is pretty high. So, California is probably the third highest, maybe fourth. There's a map that we usually put on our PowerPoint that kind of shows the different, but you can imagine the Southeast is much lower. And I'm still surprised that given that California pays so much higher and Washington, Oregon pays so much higher, that we're not stealing all those workers over here. Some of them are what, $10 in the Southeast, $9. But yeah, each state has its own adverse effect wage rate.
Okay. And I appreciate you and Richard both sharing the comment about the H-2A contractor program and how that's regulated. That was something that was new to me. One thing I actually am embarrassed to say I don't know the answer to, and I'm wondering if you do. Do those H-2A farm labor contractors, do you know if they have to register with the state's farm labor contractor registration system? Okay.
Absolutely. They do. Yeah. If they're going to apply for a H-2A labor contractor, if they're going to apply for H-2A workers and they're a farm labor contractor, they have to prove that they have both a federal FLC license and it says the initial screening on that. Ramon, I'm not sure if you're still on. Do you guys have FLC license?
Oh.
Well, he might be off to lunch.
All right, thank you. Do any of my other colleagues have any questions?
Oh, hi,
this is Ramon.
Hey,
Sorry
Julia.
about that.
Oh, hi.
Yeah.
Hi, I thank you so much for the information. One question is, to what extent have you seen issues regarding COVID with H-2A workers? I know that there are some requirements in California for distancing and housing and whatnot. I'm just wondering if any of that has crossed your desks and or your folks have seen issues with workers and H-2A housing and COVID.
Well, it has. As a matter of fact, most of our cases that we opened for 2020 after, let's say, April, were a result of publicizing of COVID infections in different workforces, and specifically in agriculture. So as you know, that we had a law that's called the FFCRA that would allow a worker to get 2 weeks of paid time off if they or a family member contracted COVID, or if they're had to take time off because their child was doing remote learning. So we opened up a lot of cases on specifically because of that. And then also, you remember that we talked about that the employer has to, and that includes the state of California opened a supplemental law that covered employers that we didn't cover with 500 or more employees. And as you know, we have a lot of ag employers that have over 500. So we were able to ask employers to pay those 80 hours by asking them to be in compliance with state law as well as with federal law. But we also, looked at housing, whatever OSHA guidance was out there, we passed that along. We did lots of outreach via Facebook, Zoom, virtual outreach to farm workers during this whole time, educating them on the FFCRA. We had a lot of outreach with employers, informing them of their obligation of FFCRA. Now that Cal OSHA has passed some of their safety measures, I believe in July or August of last year, we've been incorporating those safety measures into our enforcement. We've been also trying to protect our own workforce, and some of our investigation.
It looks like we're having a connection issue with Ruben, unfortunately. I know, Roman, I heard you pop back on, and then I think we'll go, I do, after Roman speaks, want to go to the next presenter just for time. Roman, did you want to just comment on the farm labor contractor piece? Oh, good to see. Oh, there he is.
Yes, hi. Yeah, sorry about that. We were charging our phone and having some problems. But yes,
that's okay.
We do verify using the database that DIR has online to ensure that the labor contractor license is active and current.
Great, thank you.
Mm-hmm.
Thank you so much to Ruben and Richard both. I learned a lot. Ruben's back, he's back.
I'm back. Yeah, I got disconnected somehow.
Oh, now we can't hear you.
Perhaps Santiago took me off.
Ruben, do you want to say any closing things? And then I think we'll move on to our next presenter.
No, that's it. I first of all, thank the board for the invitation. We're, very supportive of doing outreach, both to workers, farm worker advocacy groups, to the workers themselves, and with others, collaborating with other state and federal agencies to ensure, that workers are being protected. Richard, did you have any last words?
No, I just want to echo everyone's comments so far. I think this is great for us to get together and have these conversations, and it may spur some deeper and longer conversations at a later date, which we're open to, of course. And any more details in terms of training, we're always out there and available. We're always out there to talk about the significant issues that are out there. And we try to really work with employers and employer groups and employees to kind of understand their rights, but then also really put solutions out there for the workers. And some of the employers have some really good best practices, and that's even better when they share it, because when it comes from them, it's a whole lot better than when it comes from us. And one of the best ones that I ever heard was when somebody said to me, I said, well, they said, it's unfair that we have to keep the housing up to snuff. You have a whole bunch of men living in there, and they're not exactly the neatest or the cleanest. And I said, does anybody have a solution to that? And one man raised his hand. He said, pizza. Every Friday to get pizza if the unit is kept clean. And I said, well, pizza solves all your problems. But I think it's really good. Best practices, right? The men look forward to the pizza, so they keep the units cleaner. But it's good for them. It's good for us. It's good for them. Thanks again, everyone.
Wonderful. Thank you so much, Richard and Ruben, for being so generous with your time and your expertise. If you are able to stay through the end, I think there may be some other questions from members of the public, but if you're not, I understand. Next,
I can join back on. I do have another meeting I got to get to, but I could join back at 12:30.
Sure. Yeah, I think probably closer to the end of the hour, but great. We'll be here. And next, that was a perfect segue to our next presenter, Jean Malitz, who is the president of Malitz Law, Inc., who I think is here to share some perspectives from the employer vantage point and also some of the best practices that she advises for clients. So Jean, take it away.
Sure, thank you. Can you hear me okay?
We can.
Excellent. Yes. Okay, I do have my name is Jean Malitz. I am an attorney who's been practicing in California for going on 31 years and have been working in H2A pretty much since the beginning when it began to grow in California and Arizona. So I thought I would start before I jump to my PowerPoint, this will actually answer a lot of the questions I've heard earlier on how we got to where we are today. And it's interesting. Some of my clients are actually in the meeting, and one in particular is a tomato grower down here in San Diego and was probably the first H2A user in California back in the early 2000s, with the exception of sheep herders, which were the first H2A users in California. So in September 2001, after September 11th, this tomato grower was farming on Camp Pendleton, and they soon found themselves in a position of not being able to get through security on Camp Pendleton because they discovered that a primary percentage of their workforce were not legal and could not get the security clearance. So they then began to use the H2A program. And they had a fairly large program from the start. And, Ms. Rice knows them well because we know, as Ruben and Richard have said, that the beginning part of using the H2A program is always the hardest part because there are so many rules and regulations. And if you come in with a large group the first time you ever use the program, your fines can be enormous because, again, it's so complicated that you're guaranteed to make some mistake. And if you multiply that by 600 workers, it's quite costly. So moving on from September around 2004 to 2006, the program stayed pretty much 400 to 1,000 workers in California. And then 2006 came. A lot of factors were happening back then. Arizona implemented mandatory E-Verify, and the Arizona Imperial Valley area of intended employment is combined. So that meant that California growers that are primarily based in Salinas, but do work in Yuma, as well as Imperial, were in a position of having to say, well, we're not going to get through E-Verify with our employees, so we're going to start investigating into the H2A program. And that's when we became, in my office, extremely busy with education and learning the H2A program as the number of employers in California substantially expanded in that year. And it started primarily in the Imperial and Yuma region, and some up in the Sierras, and occasionally some, when I look back at my calendar, in Sonoma, in the wine grape growers. Very little H2A at that time in Oxnard, Ventura, Fresno, and other areas of the state that you've heard Roman and Cornelio mention earlier today. Very, very small percentage. It was the larger percentage was, and not even any in Salinas at that time, which is now the largest H2A grouping in the state. It all started in Imperial and in Yuma. And so the question then is, that was asked earlier, why are we seeing such large numbers right now? And again, it's kind of this merge of factors that we had a larger number of I-9 audits in agriculture, which forced employers to terminate their illegal workforce. We had mandatory E-Verify in some states. And as you know, there's proposals in legislation, in federal legislation right now to have mandatory E-Verify, and that's going to have a direct impact again on the numbers in this program. We saw a steady decline in available, whether they're legal or not legal, agricultural workers due to aging out, due to leaving the industry. And then we also saw increased border enforcement during all of this stage, which stopped the flow, or reduced the flow, I should say, of illegal immigration into the United States, which was the traditional source of agricultural labor. Why do employers want to use this program? Because it's so expensive. And that's why they want to use it? I don't think so. They use this program because it's legal, it's reliable, it's steady. They bring back the same workers every year who are the most productive. They work together and they create teams. And so we have worked with the same employers since the early 2000s who have not left the program despite the expense of the AEWR, or the AWR as we call it, going up substantially in California. So I have slides that you'll get to see the perspective on what the other states' AWRs are. And so I'm gonna, Santiago, I'm gonna share my screen and pull up my PowerPoint. Can you see, can everybody see that?
I can, yes.
Great. Excellent. So I will go into slideshow. Okay. There we go. I have up here just two federal legislative introductions. I'm not going to go into the details in the interest of time, but again, the reason why I put these slides in here is because it will impact the current H-2A program. Whether or not we see a large number of agricultural workers seeking legal residence status through one bill or one law or in the other, whichever passes, if any, will influence the H-2A program and the availability of agricultural labor in California. Farm Workforce Modernization Act just passed the House again. It passed in 2019 and is now in the Senate. And from what I understand from people in DC is that it's likely to pass in the Senate. And that has a visa component in it, as well as a legalization component for those workers who stay in agriculture. And then I will address at the end the impact of COVID on what I see from the employer perspective, because it's been a really long year and several months. I never thought I would be a COVID specialist. I never thought that the first call I'd be making in the morning was to the health department, because I'm an immigration lawyer, but now I'm more than that. Okay, so these are the statistics. You heard Roman and Cornelio talk about the state statistics that they have, and you heard them talk about the Chicago National Processing Center, which is the part of the Department of Labor that actually adjudicates the application. You have the job order part that Roman and Cornelio handle, and then you have the actual H-2A application that goes to the Department of Labor in Chicago. And these are the first year statistics for Q1. We're up 28.5% from last year in Q1. 51,181 positions sought, 48,929 positions certified. And these are the top employers in Q1. This is nationwide, not California. California, 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 and Arizona. And the rest are pretty much Florida. Okay, but this is Q1, so this is a snapshot. And here are the highest states, usage of H-2A. And again, this is Q1. So when I go to the next slide, and you can see what it looked like at the end of 2020, you've got all 4 quarters here. And you can see the number of positions certified at the end of the year. And I'll compare that to 2019. So this is the entire year of 2020. California's number 4. All depends when you get the quarter shots who's filing what when, well, who's in what season. The year end shows you where you ended up at the end of the fiscal year. And again, we look down here, you heard Ruben talk about growers associations. North Carolina is typically the largest H2A user. They have been using this program for years. Fresh Harvest California, Washington State Farming Association, again, another association, California, Florida, Circle, I'm not sure. So a big presence of California in H2A. This is the 2019 statistics. Positions certified, you're all the way in the first quarter, you were at 35. And remember, we were looking at 51 requested in 2021, 49,000 certified in first quarter. That's how much we're up in 2 years. And again, they give the list of states usage. Again, 2019, California was number 4. We weren't even on the list in 2005. We weren't even on the list in 2010. California only got on this list in the last pretty much 10 to 12 years. Here's the AWRs by state. And these are all 50 states in alphabetical order. California's 1605. But the more interesting is this is the order by the amount. We're number 2. Washington, Oregon, we're catching up because last year they were at least $1 an hour ahead of us. And this is where we are now, all the way down to the south, where you can see the numbers go substantially lower, the wages substantially lower. So we are number 2 in wages, and we still can't get domestic labor. So it doesn't seem to be the hourly wage that's resulting in unavailability of domestic labor. You had Ruben talk about the meal deduction. I think he mentioned it was $13.17 per hour, but it's $13.17 per day, where the employer provides 3 meals per day. $55 for inbound, outbound transportation per day with receipts. And farm workers never carry receipts. They're buying tacos. They're not going to a store and getting a meal receipt. And then all of this applies to both the employees living in employer-provided housing and then those meals that are provided during inbound and outbound transportation. Okay, how successful agricultural employers navigate the program today? This is when you really look at what are the best practices that you heard Ruben and Richard talk about, and there's a lot of different ways that people handle this program. You've got, as Ruben explained, fixed site growers. Those are your farmers. They own or operate their own farm, and they do the H2A program directly. The farm labor contractors are those that provide labor to a fixed site grower typically, and they are an employer, but they employ their own H2A workers. And then the associations, all of them, regardless, are required to provide the housing, to provide the inbound to outbound transportation, to provide the transportation from the employer provided housing to the work sites and back every day, to provide the meals and comply with all those rules that Ruben had on his PowerPoint. And how do they do it? Well, the number one on what I know, again, employers are the best source of finding out how they do it well. But because I work with so many of them, and we work with a lot of the agents, all of the agencies in these outreach programs, when we put together these stakeholder meetings, it's working as a team with some lawyers, with our employers, with Ruben Lugo, who's the champion to us when we first started these stakeholder meetings in Arizona back in 10 years ago, so that we could focus more on compliance and not penalties, which seemed to be the wrong way to go because it wasn't helping anybody. And what we found is that employers who put the investment into the program, it is expensive. It is millions of dollars to run this program, are the ones that do it the best. And where's that money going? Yes, to great housing. They're building housing right now. We had a farm labor contractor join up with its growers and build a $40 million housing facility in Salinas. We have Tanamora and Anil that have built that amazing facility in Salinas, where they didn't even use the H-2A program because the housing was such an incentive for farm workers that they were able to get domestic employees only, strictly because they had a really great housing facility. It's the personnel, the internal personnel, and this is where I see employers fail miserably in this program. They assign all of those responsibilities that Ruben went over to one person in their office who maybe is the payroll coordinator. That's not the way to do it. You need to have professional HR personnel. You need to have operations management involved in the program. You need to have the senior management involved in the program and understand what the program rules are, but more important, understand how to implement them in your organization, because everybody runs their operations different. And that's the key that I see the most. And Ruben mentioned that maybe it wasn't the English language H-2A users that do as well as the English speaking, but I look at it, it's the farmers, the growers that are just pure farmers do this program terribly. And the reason why is they don't have an HR department. They still do handwritten payroll records. They don't keep track of time. They don't have electronic time systems, and they're focused on getting the crop in the ground and out of the ground and selling it. They're not focused on how you get the crop in the ground and out of the ground. Who's going to be doing that work? And they're not focused on the actual employment part of this process, which is really the key to doing this process correctly. COVID resources is so important right now. I have seen employers, I've had employers come to me in the beginning of the year after, before the implementation of the ETS, but after the shutdowns, after March 2020, and say, we have invested 100% of our profits this year to COVID. We have hired internally nurses, medical professionals, safety managers, all new positions that were created to address COVID. Because I too have seen deaths. I have been woken up at 6:30 in the morning by the coroner's office in Tijuana because a positive tested COVID H-2A worker panicked, did not stay quarantined as the employer tried to do, snuck out of the housing at night, got in a van with 3 of his buddies, went out trying to get home to Mexico and never made it out of the bus station in Tijuana. He dropped dead of pulmonary heart disease. And it's a horrifying lesson to be learned. And what could the employer have done different? Nothing. They have people monitoring the rooms. They're getting them tested. They work with their county health departments. So we reached out to the Mexican consulates and said, we need your help. These workers are scared. They're very scared. And we want to do what's best for them to keep them in a safe and healthy environment if in case there's a COVID outbreak. We don't want them fleeing back home. It will endanger themselves, people along the way, and their families if they finally, when and if they get there. So that has been, our experience in the last year on really, where COVID fit in. And then I have another slide at the end, and certainly want to leave time for questions. These are the rules up on the slides now that Ruben has gone over. And he mentioned that he takes 3 days to train his employees, a half an hour here. We do 2 hours. We do 3 stakeholder meetings that run 8 hours each all day. And we drive from Oxnard to Santa Maria to Sonoma to Napa and do, an all-day show with workers' comp experts to understand how to, what type of coverage is going to be covered by workers' comp. And that's another issue with COVID that we're having issues with, because workers are getting tested in Mexico, which is great because we want to know if they are COVID positive before they cross the border, not when they get here. Because if they test positive the day they get here, they're not going to be covered by workers' comp, because workers' comp are denying those claims because they're here only for 1 day and they're testing positive. They certainly didn't get it here. And so those claims are being denied right now. So we want them tested in Mexico twice, 2 weeks before they come. And then if they're flying, the 72 hours before they actually get on a plane. And then we know they don't have COVID when they get here, or at least that's what we're seeing. So I'm not going to go back over all of the rules that Ruben went over, but most important in these rules is to treat your employees well. And I think that that's one thing after reading your mission and understanding, the goal really with the stakeholders and with the government agencies that we work with. The employers will not retain their workers if they are not treating them well. And the employer does not want to invest more money in litigation defense and fending off wage and hour claims. So they have no interest in doing that. That doesn't mean they don't make mistakes, because they make a lot of them. And believe me, when I hear about them, I'm like, how could you do that? I thought we went over that. But it doesn't always stick, because I don't take 3 hours to train. I don't take 8 hours. I take a whole season to train a new H-2A employer. And for our seasoned H-2A employers, it's just ongoing. It's part of what we do. We do not file paperwork and walk away like some visa lawyers in other types of visa programs. This is not that type of program. We work with the contracts, making sure they say the right things. We work with the EDD. This year's questions were on inbound, outbound transportation, and when the employees are being reimbursed, should they actually outlay any of those costs, and making sure that the language in the job orders is meeting the legal requirements as everybody understands it. So there's a lot of discussion, and that's what's so great about the Department of Labor in this program. All of these agencies that Ruben had on the website, State Department, amazing outreach. Always come, they come to the farms, they come to the tomato farm in San Diego, along with the Mexican consulate. They meet the workers. They have the opportunity to ask questions of the H-2A employees. And then we work extremely well with the OFLC, that's the Chicago National Processing Center, the EDD, the Housing and Community Development Department. We had a meeting with their management yesterday, because they do the housing inspections, on how an employer can best, by getting that application in for their permit to operate their employee housing, they want those permits in 76 days before the advance, which is a scramble when you're trying to get new housing under the ETS. But we work with them, we talk to them, we let them know why that's maybe not going to be possible. And then we work with Ruben's group at Wage and Hour and all these stakeholder meetings. The only agency, and hopefully this will change with Secretary Mayorkas, because he was a USCIS director at one point several years ago, is the USCIS. That's the Immigration Service. They don't talk to anybody. They don't answer questions. They don't communicate by email. You have to go through a separate ombudsman's office, and they are really, really difficult to get to reach. And so that's the one agency in this whole process that isn't very helpful. And I did mention, throughout my presentation, some of the COVID-related measures that we've been taking. And then California's, restrictions are the most strict in the country. Washington and Oregon are second, but they're not as restrictive and strict as California. And we're hoping, because it's been extremely costly to get, to have to double your housing when you have to have your housing because of the distancing requirements. But we are getting, the employers are having these workers vaccinated. In fact, I got vaccinated on the farm with the farm workers. And unfortunately, I got the Johnson & Johnson shot, which I'm not too happy about this morning. But I think that what I've seen really is the efforts that employers have made to keep their workers safe and go the extra yard. So when we had an outbreak this week, I get called by the farmer, said these workers just got here yesterday and 10 of them are testing positive and one of them is hospitalized, but he's now being released, but he's on a feeding tube. And my question, of course, is why are they releasing him? But he's being released back to employer housing. because he's an H-2A worker. And the question then is, are we required to hire a nurse? I said, well, you're not legally required to hire a nurse. Workers' comp is not covering it because they denied the claim. But like Ruben said earlier, the last thing you're going to do is leave this person unattended in your house, and you're not sending him back to Mexico because it's not safe and he's not well enough. So hire a nurse or go back to your local clinics, because that's where that question came up earlier. Almost all of our employers either now have in-house medical personnel or have partnerships with clinics where the employers even pay for some of the medical costs. If the employees are eligible for affordable health care under the Affordable Care Act, they are offered health care, but as Ruben said, they don't want the deduction and they decline. So the second best option is to partner up with local health clinics, and now under COVID, with different associations. Grower Shipper's been tremendous in the COVID resources. Ventura County, exceptional in providing COVID resources, medical emergency source resources. Those phone numbers are given to workers. They're given out in training meetings. There's constant training on safe practicing, distancing, housing. Workers live in the same, what that we call pods or groups. They travel with the same group. They stay on the same crew with the same groups, and that we were doing that way before the ETS procedures came out. We learned fast and we learned hard because early on in the COVID, there were outbreaks and we did have some deaths.
Jean, if I may ask if you can, you might be all there already, just to wrap, because I do want to try and get to Cynthia before 1 o'clock. We can stay after 1 o'clock, but I realize I want to be respectful of everyone's time.
No, I'm actually finished. And if there's any questions, happy to answer.
Well, thank you so much. I think if my colleagues will hold, I think we'll go right to Cynthia, and then if you're Cynthia Rice, and if you're able to stay after, I do have some questions. It's a very informative presentation. Appreciate it. With that, I'll turn it over to Cynthia Rice with California Rural Legal Assistance, otherwise known as CRLA.
Great. Thank you very much. And thank you all for having me here. CRLA, as probably most of you know, is a statewide legal services organization. We have offices in all of the major rural counties in California, and including and certainly in those areas where Ruben and Cornelio and Jeannie have indicated have the highest impact of the use and implementation of the H-2A program. We have been involved in representing workers, both domestic workers who are affected or displaced as a result of the use of the H-2A program, as well as H-2A workers who have come in and have been subjected to violations of both the H-2A program requirements as well as California and federal law. Let me just begin by saying it's not complicated. You don't displace U.S. workers. You recruit U.S. workers who you haven't hired before to make sure that you fill job openings that you have. You follow state and federal laws that set minimum requirements for housing, transportation, and payment. And you treat your workers with respect. It is the violation of those things that required that those regulatory specificities that Ruben and Cornelio have referred to is because employers just won't do what is the human and normal and natural and good business practice approach to using this program if you truly cared about the workers in your community instead of your bottom line. So we have been involved in the H-2A program litigation since the first uptick in San Diego County. And as Ms. Mallitz pointed out, one of the first users of that program was in fact the subject of one of our pieces of litigation. And there were other users as well in San Diego County. And again, this wasn't these weren't violations of very technical requirements of the H-2A certification process. In one case, a U.S. District Court judge issued an injunction because the employer had displaced some 80 U.S. workers because they had H-2A workers coming in. And so one of our concerns about the use of the H-2A program, and I think the reason that Ms. Mallett has this emphasis on human resources personnel is that once an employer makes a commitment to bring in H-2A workers, they've made that financial commitment, and they basically are going to do what they need to do to make sure that they can carry through with hiring and employing the H-2A workers that they've recruited down in Mexico or in other parts of the country. And that sometimes means, and often means, giving short shrift to US domestic workers who have had those jobs in the past or who would be available for those jobs, except for some of the restrictions on applications, the limited recruitment. There's far less recruitment of US workers done than there is of workers in Mexico under this program. That's just the reality. And with respect to the difference between who's violating and who's not violating, if you took a look at Ms. Mallett's slides in terms of those farm labor contractors, we have successfully litigated or negotiated settlements pre-litigation or had labor commissioner complaints against most of those farm labor contractors. So it's not a matter of the farm labor contractors getting to know the program and complying with the program versus the growers. It is a matter of the fact that this is a program that is designed to allow employers who would do so to violate the law with not a lot of oversight. And Ruben and DOL are doing their best. And as he said, almost every H-2A investigation that they open, they find violations. I think Mr. Longo said that. That's certainly true for us as well. What we find is that we have workers that come into us, we identify problems, and they're too frightened to pursue those problems. So even the success that we have at the Labor Commissioner, at DOL referrals, at EDD, work with HCD, and in our litigation is in our view the tip of the iceberg of the violations under these programs. So if it's so expensive, why do growers do it? We acknowledge in the last few years, as a result of US immigration policy, there has been pressure on the agricultural labor force, and there has been in some areas a labor shortage. We are also hearing reports right now in the Imperial Valley that workers who are on unemployment are not able to find work, and there are job postings in the Imperial Valley under the H-2A program. We're hearing the same in Salinas. We're hearing the same in the Central Valley. So there continues to be a disconnect between US workers who are in the areas where these jobs are going to happen and actually hiring them. But one of the reasons, and in our view, really the motivating reason to a great degree, is that the H-2A program is attractive, is that once the H-2A workers are here, once they've gone through that procedure of getting a certification, those workers come into the country, they can't vote with their feet. They can't vote with their feet without losing not only their right to work, their job, but their housing, their transportation, and their right to stay in the country. Kind of sloughed over the fact that this visa program is employer specific and transferable, but only at the option of the employer. An H-2A worker cannot actually apply to transfer to another H-2A employer, even though there might be openings with a more favorable employer. That can't happen. So there is complete and total control over these workers by their H-2A employers. And often, as Ruben pointed out, Mr. Longo pointed out, they come into the country with a debt load. Some of that has to do with the recruitment fees that they've paid under the table, either directly in connection with grower recruitment or FLC recruitment or to third parties, but also their transportation into the country isn't always paid upfront by the employer. As Mr. Lugo pointed out, it's reimbursed, but only later on. And so they come in having paid to get here, paid for their jobs under certain circumstances, paid visa fees, et cetera. So they've already made an investment that they really can't afford to turn their back on. And as we all know from the news, they're fleeing a country who now is way more hit by COVID than we are and has been in an economic decline for a long time. So it is a captive workforce, and it really can't be considered as anything but that when you're looking at this program and what best practices are. I wanted to focus a little bit, because this is the ALRB and perhaps because of the Cedar Point argument, on the issues of access that affect the ability for us to get to H-2A workers and advise them of their rights. And I'm hearing EDD and HCD even to get access for the purposes of doing these inspections and these oversight reviews that we're talking about. As I said, the H-2A employer controls the housing. They assign it. It's not, oh, I'd like to be here with my friend Roman or Jesus. They're assigned to particular space. Increasingly, the H-2A housing is not in traditional barracks or farm worker housing with 4 or 5 men to a room. It is in single family houses that have been converted to multi-room, multi-worker housing configurations, sometimes as many as 25 workers in a single family home. And it is, and they're increasingly relying on what used to be SROs, single room occupancies, Motel 6, Motel 8s, Days Inns, other low rent, low cost motels. Now, one would think that this would actually improve access if they're at a Days Inn as opposed to a farm labor contractor site. Not the case. In one of the orders that I was just reviewing the other day, I came across this very specific limitation on the housing that was actually included in the order approved by both EDD and by the U.S. Department of Labor. And this job order specifically says, no visitors are allowed without written request by employee to the designated H-2A housing manager. Requests for visitors may be denied for no cause, and no members of the opposite sex may be in the housing rooms at any time. So that is the scope of control that these employers exercise over these workers. That not only is it where you go to work and when and where you live, it's who can visit you, and we get the right to reject anyone who comes in that you would like to visit you. That makes our outreach and our access extremely difficult. And there is our CRLA Foundation is another organization, actually had an outreach worker thrown off the premises about 2 years ago, and a letter written threatening to charge that individual, to report that individual to the police for trespass and to bring action. So it's not as though there is access to these workers to folks like CRLA, folks like CRLA Foundation, the Dolores Huerta Foundation, and MyCop and Cause, who are out there doing workers. It is a major barrier to overcome to be able to work, to be able to access these workers. One of the other things that is really interesting about the recruitment and the isolation of these workers is that if you look at the job orders about where one is to apply for a job, to drop in for those job applications, they are not where the work is. They are where the home base of the company is. So in one instance, all work applications have to be submitted to the home office in Hemet. This is a farm labor contractor that has operations in Imperial, which is Hemet, Riverside, Kern, Salinas, Fresno, and Stanislaus. So is a Stanislaus worker going to go to Hemet to find these jobs? No. So we're not talking in many respects about an integrated workforce. we're talking about increasingly an exclusive workforce. And if you look at historically the development of H-2A program in, say, Florida, North Carolina, Georgia, as it inched up, you get to a point where 70 to even 90% of workers in like sugarcane and tobacco, 90% of that workforce is now H-2A only. And that is the trajectory, I'm afraid, that California is on in certain respects, unless there is kind of a pullback of some of this program. And with that comes isolation and fear of retaliation, and a vulnerability that is not the same as the vulnerability that US workers have. Because even though California doesn't rely on foreign labor recruitment to the extent that most states do, a lot of FLCs and growers actually do their own recruitment down in Mexico, or at least actively involved in it. There is most assuredly a blacklisting that takes place with respect to H-2A workers. And there is a network, and there are about 100 employers in California, H-2A employers. All of those employers know each other. They're represented by maybe 5 or 6 major firms and then a few other firms. And so if a worker complains and then goes back home, that worker can expect never to be offered an H-2A job again. So that increased level of vulnerability to retaliation and discrimination is a very real aspect of the H-2A worker's life. So access is a problem, vulnerability is a problem, and then knowledge is a problem. As Ruben pointed out, there is an extensive H-2A contract that is given to the worker. That H-2A contract is largely boilerplate now, as Roman pointed out, which actually makes it worse in California, because much of the boilerplate that is included in that written contract is inconsistent with California law. So, for instance, the reimbursement for employment-related expenses. Under California law, if the first week of work you make less than what your out-of-pocket expenses were, they have to pay you for your out-of-pocket expenses. The job order says you get payment for those out-of-pocket expenses after you completed 50% of the contract. So what a worker's told is completely in conflict with what the law is in California. Deductions. The boilerplate in an H-2A order says deductions from your pay can be made for negligent or loss of tools. That's against the law in California. Now, we've negotiated with EDD, and happily, they have required growers to include qualifying language. That qualifying language, because of the boilerplate way that the new order is set up, is in a totally different section. So, and it's in a section that's later than that first section. So the first notice is that it gets is that a worker doesn't get reimbursed if they lose their scissors or their clippers or their gloves, right? There's nothing in 90% of the orders about California overtime. And even those orders that address California overtime don't generally identify when it kicks in. They'll say overtime will be paid when appropriate. Doesn't say anything about the phasing in of overtime that's now in effect. Doesn't say anything about what the rate of overtime is, and it doesn't say anything about how many hours you have to work before overtime is applicable. Doesn't include meal and rest provisions, doesn't include any disclosure about sick leave accrual, doesn't include any disclosure about heat, safety, or other field sanitation or job requirements, and it doesn't include a word about the ALRB. There actually, in some of the orders, interestingly, it talks about the fact that collective bargaining rights under the under some laws, including the NLRB, may be applicable, but it doesn't say anything about the ALRB. There is no reason for a California H-2A worker to even know that the ALRB exists. In terms of housing and worksite locations, again, from the perspective of the ALRB's outreach and their kind of systemized approach to this, you probably know this, but I'll post the link in the chat. There is website access now to all active orders that is available on the DOL website. And the good thing about that website is that those orders include not only the actual work sites that these workers are supposed to be at, but all of the housing locations. So you can actually focus your outreach to specific housing locations by grower or FLC based on those that are disclosed in the job order. Now, the bad news is that's exactly what CRLA's approach is. And more times than are just coincidental, we'll get out to a housing location and there are no workers there because the employer has changed the housing up in the middle of the contract, which means that those workers are now being housed somewhere that has not been inspected, has not been approved by DOL, and that we can't find. And again, that's not an isolated instance, particularly in the Santa Maria Valley. That's something that we're finding quickly. Let me just say, we have also been in communication with EDD, and they have encouraged us, if we find that kind of situation, to report it to them and they'll follow up, which is great. And as the ALRB anticipates and actually establishes more outreach to H-2A workers, I think it's really important that relationship between ALRB and EDD, ALRB and DOL, for them to be able to go in and do these inspections, investigations, and follow-up proceedings is really, really important. All right. So Ms. Mallitz painted a beautiful picture, and I would love it if that were what we found when we are encountering workers who are H-2A workers at the various employers. Certainly there are some who are doing their best to follow the law and are doing so. And there are some FLCs and some growers that we've never had a complaint about despite outreach. And we have a comfort level that they are doing a good job. It certainly can be done. From our perspective, the very nature of the program does not encourage compliance. Because these workers are so isolated, because once the investment in the H-2A program is made, it actually costs money for the employer to then go ahead and hire domestic workers. And because if they go back to their domestic workforce, they lose the level of control that they have over this workforce. So in terms of the kind of violations that we see, one I talked about right off the bat, the California requirement for reimbursement of out-of-pocket costs within the first work week. Two reasons that this happens. One, the employers just don't want to pay it. Two, workers are never notified of this right. And as Ms. Mallitz pointed out, they don't keep receipts, right? Well, because they're never told that if they keep receipts and put in for this money, that they'll get it paid back. I have yet to encounter an H-2A employer, and perhaps Ms. Mallitz has some, who has a process, even at the 50% rule or at the end of the contract, for asking workers to submit their expenses for transportation into the country. They just don't do it routinely, and therefore that's, I think, thousands, if not tens of thousands, if not hundreds of thousands of dollars over the course of the last several years that employers have not had to reimburse workers who came into the country to take these jobs. Kickbacks are very common. Again, transportation is supposed to be free, but we frequently hear that the worker is required to pay the mayordomo $100 every pay period to cover transportation or housing or both, to pay for cleaning. Not all of these payments are prohibited, but exist. Unpaid waiting time pre and post ship. This is very, very common. And in fact, some of DOL's litigation in H-2A has been about waiting time in the fields, both just, excuse me, both a function of, whether or not the crop's ready to go in, whether or not the other I'm sorry, the mayordomo is there, whether the other crew members are given the same time to report. Almost all of our H2A workers report that they don't get to the field on the bus and then start to work. They have to wait 20, 15 minutes, totally uncompensated time. Same for the end of the day, that they stack tools, they unhook the toilet, they load equipment, all of that is off the clock. Additionally, transportation time under California law, unlike under federal law and under any law in any state in California, transportation time is compensable time under certain circumstances. And employers have gone to great lengths after we have won many of these cases to post placards on the buses that this transportation is voluntary. Workers can take it if they want to, but they don't have to. They're certainly free to do whatever they want. And based on those disclosures, which are also included in the H2A contract, they take the position that that time is not compensable, even though workers are told what time to get on the bus. They're reprimanded if they don't get on the bus at that time. They have no other way to get to the fields. They have no other way of knowing where the fields are. And they have no way of getting back from the field except by virtue and operation of the employer transportation. So that's the other major issue that we see, and that workers have no idea about how to even analyze whether or not that is compensable time, because in the order that they're given as their job contract and on the placards on the side of their bus, it says this is voluntary, that you don't do it, it's not going to be compensable. The meal and rest period violations we see in almost every contract, short lunches, late lunches, delayed breaks, waiver, quote unquote, of breaks based on the mayordomo's recommendation that y'all need to waive your second break today so that we can go home at 2 o'clock. That's not a meaningful waiver. That's you do this and we're going to call it a waiver. They come along with wage keeping, record keeping violations and the whole panoply of other violations associated with not complying with California meal and rest provisions. And again, H2A workers aren't really in a position to complain about that because they don't know that they have meal and rest period rights under California law, because those are not disclosed in their H2A contract or in the placards that Ruben was talking about that summarize largely federal obligations. The other ones that we see, and these have not gone away with the COVID-19, are overcrowded housing. Again, what we have seen frequently is that housing gets certified for a certain number of workers. Then not all of the housing is utilized. They overcrowd some housing and they leave other housing vacant, meaning that a housing that was certified for 18 to 22 workers all of a sudden has 35. And DOL has certainly done inspections on that level and violations as well.
Cynthia, may I ask you if you don't mind wrapping closely, and then after that, I do want to check in with our interpreter too to make sure she's okay.
Sorry about that. Sure.
If she needs a break. No, that's all right. It's very interesting.
What I found interesting is one of the things that wasn't mentioned is the bad food. And I know that Ruben Lugo and I and some of the other staff from DOL have frequently had conversations about what a high incidence of complaints there is about bad food. Obviously these are guys that are, and they're almost 95% guys in California that are working 8 to 10 hours a day, 6 days a week, and backbreaking work. And really consistently the claims that the food is not enough, that it's not nutritional, that it's spoiled. And again, this is one of those financial bottom line issues that I think there's a lot of corner cutting in the H2A program. Their cost of the housing is pretty much fixed, whatever they've negotiated with the housing provider or their own mortgage payments, but they can recoup some of their projected costs by limiting the food. And again, it's a persistent problem that we see. Finally, we see a lot of discrimination in H-2A in a whole different variety of ways. At the initial recruitment site, we're seeing orders that specifically say a worker must speak Spanish or English only, which has a disparate impact on the indigenous community, because increasingly the farm worker population in California, the only part of that legal domestic population has been steadily increasing is in fact in indigenous populations where they don't speak Spanish and they don't speak English. So that discrimination actually excludes those workers. Women are largely excluded from recruitment and the program because it would require separate housing, but also just because I think they're harder to control, frankly. They complain more. That's our experience with working with the farm worker community. Workers who complain get sent home. They're terminated and their right to work is extinguished. And if they stay to pursue their rights, they're technically out of status, which could be a basis for refusing them entry into the country under any other visa program in the future. And that is a big disincentive to their complaints. So one of our recommendations with respect to the ALRB is, in anticipation of that, we think that under certain circumstances that could be the basis for a U or a T visa, that kind of retaliation, because it does rise to the level of a criminal act. And so for the ALRB to be a certifying agency for the purposes of a U visa for a worker that has been retaliated against as a result of engaging in concerted action is a very, very important thing for you all to consider. I'll stop with that. I know there are a gajillion other things that I would really like to say, and I know that I'm hoping that there are some questions that I can answer, and if there's any clarification I can provide, I will. And let me post that link in the chat to the DOL site.
Okay, thank you. I definitely have a lot of questions for all of our presenters, for those who are around, including you, Cynthia. I do want to give our interpreter a break. She's been working hard this whole time. So we are going to take a 5-minute break. Is that okay? Checking with our interpreter. Okay, great. So we're gonna take a 5-minute break. Santiago, if you don't mind throwing up the timer, just because I think that's helpful. I'm clocking it at 1:11, so we'll be back at 1:16.
Thank you.
Thank you.
Okay.
All right. Okay. Thank you. And thank you so much to our interpreter for working so hard. Really appreciate it. Santiago, is everyone able to hear me? Okay, great. Great. Okay. Thank you to all of our presenters, and thank you, Cynthia and Jean. Sorry that we had to kind of close it both of your presentations. I do want to open it up first to my fellow board councils, or excuse me, fellow board members, to see if they have any questions specifically for Jean or Cynthia. I know, Barry, you had one thing you were mentioning just now. Yeah.
Yeah, I don't know who would want to address this, but does this program or whatever the plan for this year require these employers of workers in this program to take specific responsibility to make sure that the workers get vaccinated? Who actually gets them to the vaccine site? Does the employer have any part in that? Or is that an individual private responsibility of these workers?
I can answer that. The way that we've been seeing is our employers have contacted. In one case, when I got my vaccine, it was CAL FIRE that came actually to the farm. And then in other locations, employers are working with either private health clinics or the local county officials who are coming on site to the employers. And in some cases, the employers will bus the workers to the vaccine, but none so far that I'm aware of have mandated that the employees take the vaccine because they want them to have the opportunity for religious reasons or fear to decline should they so wish, just like any employer would do. It is not absolutely mandatory in most cases.
And in terms of program requirements, at least as far as I know, the OFLC, the Office of Foreign Labor Contractor, DOL, EDD, none of those agencies have provided specific directives about what employers are to do either with respect to vaccination or even quarantining. They're all deferring to the local health agencies or the state or federal emergency announcements.
Right. Yeah, I think that they're deferring to experts, just like everybody, every employer.
Do any of my other colleagues have any other questions?
Too tired.
Hi, Julie McGurn, really quick, just wanted to respond to something Cynthia had said about the ALRB certifying for a U or T visa, and just wanted to mention that we have actually, or I've signed a certification before for worker, but just the challenge has been trying to fit it into the box of the qualifying crime. So just, I'd be interested in hearing more thoughts about that, perhaps offline.
Okay.
That you have.
One question I had both for Ms. Mallitz and also for Ms. Rice, and not to start a debate, I just am really, and it really piggybacks off of the question I asked of Roman earlier in the presentation about recruitment. And maybe we can start with you, Jean, just kind of what are the efforts that employers go through to recruit domestic workers? And then maybe Cynthia, if you could kind of expand upon, you've indicated some concerns about that, but maybe you can expand upon that too. Jean?
Yeah, the rules in the H-2A program, and I'll just start there. What they do outside the program is separate. In the H-2A program, once you file your application with the EDD will accept it and open a job order, which gets circulated eventually to a website that is called seasonaljobs.dol.gov. So and Cynthia mentioned that earlier, all job orders, the whole thing gets posted onto a website that everyone in the country and outside the country for that matter have access to. And the employers also, and this is where the Munger Farms came in, the employer is required to contact their last year's workers who worked for the employer at the place of employment. And the statute's very vague, and we've strongly worked with wage and hour in saying, well, what does that mean? We typically, if there's a specific like strawberry requirement, an employer will contact all its strawberry workers because they have to meet the requirements in the job order. But if there's a general ag requirement for that matter, then we employers are required to contact all of their former seasonal workers from last year's season. And that's the solicitation of last year's workers. And that's where people get into a lot of trouble, as Ruben said. Wage and Hour came out with a different interpretation, which we follow now because of what happened in Munger. In Munger, in the previous season, they had hired a labor contractor, and then they did the H-2A program directly. And so they didn't have any of direct employees the previous season, but DOL came out and said, well, you should have contacted your farm labor contractors employees from last year. And so that, creates some issues, but if that's, the policy and that's the interpretation, then that's what we do now. It's just hard to solicit somebody else's employees away from them when you have a non-compete agreement and things, certain contractual obligations, to say, hey, we're going to take your employees and hire them directly this year and you're out of luck. But that is Wage and Hour's position, and I can let Ruben or Richard address that. But we used to have to advertise in newspapers, but that's gone because nobody ever answered the newspapers. And that's the primary recruitment in the domestic recruitment. I do want to, if you don't mind, when Cynthia said you have to travel to make the application to a work site that's not in the area where you live, but all the employers are required to give email addresses and phone numbers, and people can apply by phone or email or in person.
If say you had an employee that was picking strawberries and maybe you're shifting to raspberries, or that's where the need is there still an obligation? Do you break it out? Are employers required only to reach out to those employees who picked that commodity, or is it to any crop that they've grown?
It depends on what your experience requirement is in your job order. So you can, a lot of employers have experience requirements that say we must have 1 month of experience strawberries, let's say. But you may have another employer don't want to limit it to that. So they may say must have experience harvesting berries, then we would reach out to more than strawberries, or must have or a more general agricultural experience that says must have at least 1 month experience working in agriculture. And then you would reach out to all of your commodities, assuming you have employees that worked in different commodities the previous year. So it really depends, because they have to meet those requirements if you have that requirement in it, just like you can't hire H-2A workers that don't have those requirements either.
But they do. I mean, that's really the problem.
They're not allowed to. Right. They shouldn't. They are not allowed to do it.
They're not allowed, and they shouldn't. And in fact, by imposing requirements that we see are largely not imposed as a matter of general practice, what employers are able to do is actually reduce the job applicant pool. The other thing that happens is that, particularly with FLCs, and this is particularly in the Salinas Valley, there is a linking together of discrete jobs that had not historically been together. So in King City, there's always been a huge chili and pepper harvest, and workers there became very skilled at it. Well, now almost all of those jobs are put together with a FLC order that is for lettuce and other row crops that's further up north in the Monterey area, in the Salinas, Santa Cruz area. And then the housing is put right in the middle, so it's 75 miles each way. So they've created these kind of artificial places of need that have taken away from the local recruitment efforts. But yeah, they used to have to do newspaper ads, and they were ridiculous. No one responded to them, so no one cared when that regulation went away. The other thing that we have not really been able to crack this nut, and I'm thinking that is something that ALRB really wants to take a look at, is that it goes the other way too, in fact, more often, and that is that you have a grower who switches over to a farm labor contractor, and the farm labor contractor doesn't bother to get the grower's list of employees and recruit them. What we also don't know is whether or not there are situations where a grower who is under contract is letting out some of those places, some of those locations to farm labor contractors, and whether or not there is enough accountability to ensure that workers under the contract are notified of that, and that workers under the H-2A workers are even notified that they're under contract if the work continues, when the work continues on that particular grower's job site. That's not an issue that we've seen, but it's an issue that we're concerned about as the program increases. And as Ms. Malice points out, and I think Ruben or Cornelio noted, there are more smaller and smaller orders coming through that are grower specific coming through in the last year. Right now, there are orders active for 19,000 workers in California right now. If you add up all the ones that are active on the DOL side that are specific to California. So that's without peak harvest in September. That's without getting into what's going to happen in the winter harvest in Imperial. So, and the number of employers is increasing. It was a handful in 2010. It was about 100 last year. I think it's probably closer to 100, 115, 120 this year, and we're not at harvest yet. So, the recruitment issue, I think, is an important one.
Another question I had, and this is actually spurred, I think we want to do a whole panel on housing, farm worker housing alone, just because there's so many issues. But Senator Hertzberg, when I spoke with him a couple months ago, was asking me about, the state in the last few years has enacted several different housing bonds that have included monies for farm worker housing. And I don't know, does any of that go to support H-2A worker housing in any way? I'm kind of going out maybe outside your direct area of expertise, but I'm wondering if either of you are aware of that.
Well, there used to be a prohibition on Section 514 funding for H-2A, expressly prohibited. I think that's federal, but I'm not sure about the state. But no, at least our employers are using their own money to build their own housing. They have not received funding, to my knowledge, from the state. But the Farm Workforce Modernization Act has provisions in it that would allocate a significantly increased federal funding for building new employee housing for H-2A. And that was probably one of the better provisions in that bill. Yeah. But at state level, I'm not sure.
There was a farm worker housing bill that passed last year that provided for some funding, but I don't believe it's yet fully funded for farm worker housing that that excluded H-2A housing exclusively for H-2A workers. And the rationale being, and really the impetus behind that limitation, was that there has been a lot of pressure on low-income housing in areas where the H-2A program has increased, because, as I said, they're taking single-family residences as well as SROs out of the housing market, at least during peak season. And so there is at least one program that's restricted that I'm aware
of. And then you had mentioned kind of the visitor exclusion provision, and I'm wondering, either Cynthia or Jean, if you can comment on, I guess, is that regulated in any way? That strikes me as a little bit odd, that workers may not have access to visitors if they're choosing. And I just don't know if, and maybe DOL can comment on that too, of just how that's regulated and overseen, if there's any regulations that provide oversight about that.
The only specific language that addresses it in the context of the H-2A regulations is the guarantee of access to labor organizers. We, if you look at California law, the access guarantees under California law to employer housing are much more rigorous, and we think those provisions are illegal. We have, tried to get EDD or DOL to refuse to allow them, and have been unsuccessful. And they're not only in the H-2A orders themselves. What happens is that after the workers come into the country and move into the housing, they'll get house rules that won't have been disclosed at the time of recruitment or in the contract, but include these kind of access limitations. And they've gotten way worse with COVID. Right now, there are postings at some of the, particularly the motels that are being used, where workers are directed not to leave the housing except to get on the bus to go to work. And when they return to work, not to leave the housing at night, except to go to authorized grocery and laundry runs that are supervised by the employer.
Jean, I think you had some comments too.
Yeah, I mean, I actually think it was very, very successful in her work with the EDD, because several years ago, there were numerous letters from CRLA to the EDD asking about that provision in job orders. And we actually worked with the EDD and changed it, because if it was too restrictive, we wanted to make sure that the employees understood. And that was one thing I wanted to address. The employees H-2A get copies of the job order and the contract, which is typically the same, just so, to understand, in Mexico before they come. And they don't just get handed copies. The employer goes through every single page of the job order, and it's in English and Spanish, before the workers come into the country from Mexico or whatever country they're coming from. And the domestic workers who are working alongside the H-2A also get a copy of the same contract, even if they're year round. So, and in at least in our job order, we have subject to the right to access and right to assemble provisions, and we cite the code sections, which is going to be gibberish to H-2A workers, which is why we try to streamline this and make it simple. That visitor restriction is really designed to be for the safety of the worker. And we had people bringing in prostitutes. You have to understand, you have people throwing parties. You've got people getting pregnant in the middle of their job orders. So there's some restrictions that are not designed to be something that was making, keeping the workers under control. It was more designed to protect the safety and welfare of themselves and other workers, but subject to the right to access, which is completely not limited in any way. We follow what the California rules say.
But again, in our experience, that's the exception rather than the rule.
But I give compliment to Cynthia. She brought this to the EDD's attention, and it was very important that we educate our employers in not having these provisions that, restricted unreasonably so.
Right.
And I agree with Cynthia on that.
Yeah. And that provision that I just read to you is from a current order posted on the USDOL site by the largest farm labor contractor in the state and one of the top 3 in the country for H-2A employers. So it continues to be a problem.
Ralph, you had raised your hand a little bit.
Yeah, this I'm not sure who the question's for. It's kind of taking us back to the recruitment. Well, it's really, I'm interested in the profile of if we're increasing the number of employers that are participating in the program. Do we know anything about how many of them are LLCs that are just created for short? How many of them are new employers that were? I have an impression, at least, that some crops are LLCs are being created. A crop gets planted for a couple of years, then it disappears, and then another one is created. Do we know anything about newly created employers being the ones participating in the program?
Some are, and maybe if Cornelio is on or Roman is still on, the issue of the day right now, at least at the OFLC, which is the Chicago Processing Center, is seasonality and temporary. And really looking in depth at farm labor contractors that may be working year round in one area of intended employment, and what the nature of the work is. And they also look in doing this to see whether people have entities have been set up that are owned by the same parent company and everything is the same, where that they can work year round. And so that is scrutinized very heavily right now. The denial rate is enormous in the last 6 months at the Department of Labor in Chicago on that issue. Okay, so it's not something that is happening without awareness.
And we have seen, the same way that we saw kind of the rise of quote unquote farm labor contractors or small operations when growers wanted to get out from under their own employment verification requirements, et cetera. Foremen all of a sudden became business owners. We've seen a little bit of that in the strawberry industry in the Central Coast area, less so in the Salinas area, and I'm not seeing it in other parts of the state.
Thanks.
An additional question I had was, Cynthia, you had mentioned kind of can you guys still hear me?
Yes.
Okay, we're having a TV issue, but you had mentioned the issue of you're finding that there's some employers that are maybe switching up the housing mid-contract. And I'm wondering, probably Ruben or Richard could maybe best speak to that, but I guess can either of you speak to that, and is that permissible, and how do you address that if it's not?
Not sure if Ruben is still on.
I am.
Both of you are.
Okay, I'm here if you need me.
Well, it is a violation when an HLC will change housing in, and we have found that in several of our investigations. We've seen some H2A users put a certain motel in a certain city, and then we saw maybe 2 or 3 others use the same motel. And if you really add up all the rooms for that hotel, the sum of the workers requested by the 3 FLCs is much larger than the available rooms in that motel. I think what's happening is that some H2A LCs will put a motel on their work order just to get approved, and really don't have an actual contract with that motel, and then go elsewhere. So I mean, that's a problem we're dealing with, and because most of the time the new housing is unsafe, and we've also had incidents where an H2LC has a contract in a certain area and has a contract in a area maybe 10 hours away, 12 hours away, but they find work in between those 2 areas and works their H2A workers in an area where they don't even have a contract in, and puts them in a really bad housing. And EDD has no idea what's going on. Chicago DOL has no idea what's going on. And the only way we could find out these things is when we get competitor complaints or third-party complaints saying, hey, there's a bunch of H2A workers over here, and I don't think there's a contract for them. And so we end up going out and checking that out. And usually the housing for those workers are really bad. They're not inspected. No, EDD doesn't know about it. Chicago doesn't, ETA doesn't know about it. And this is becoming quite common now. So we're trying to get a handle on this trend that we're seeing. And hopefully our enforcement efforts that we're working on will discourage other people from doing it in the future. Hopefully that answers your question, Victoria.
It did. Thank you.
And I think there are circumstances where you have to change housing, wildfires, COVID, and we are required under the DOL's FAQ especially during COVID, to immediately notify the department and the EDD to set up that housing inspection. And I will say that yeah, you are moving the workers to uninspected housing due to an emergency, which is unavoidable. So,
Right.
you know,
Yeah, but
reporting
there are
and
very specific notice requirements under the regulation and
Correct.
the FAQ. And what we're
Correct.
finding is there isn't any notice of these changes, as Ruben pointed out.
Well, there's
So yeah, you can do it if you need to, absolutely. And you know, we would not object to that at all, and we know that some of the H2A housing in the Sonoma County area, they had to temporarily relocate. So yeah, but there is a process to do it, and that's not the problem we're seeing. We're seeing the process exactly as Ruben identified, that either the housing became unavailable because someone else had leased it out before the workers got there, or we have a situation in Santa Maria right now where there was some construction being done that completed before the workers came in, so they just shifted them over somewhere else, but no one was ever notified about it.
Do
any of my fellow Cornelia?
Yeah, if I could just jump in for a second. Ruben is right there. You know, the other speakers also are right. If the employer doesn't notify us, we're not going to know. However, EDD has a practice and a policy to follow up at the 50% of the contract. So if an employer has a contract for 8 months, at 4 months, we're going to do a follow-up housing inspection. At that point in time, we'll be able to identify if the employer has basically moved the workers, right? Because when we do a follow-up, we have a list of the housing locations, right? And we also have a list of the capacity for that. Something else that we implemented about a year and a half ago now to avoid FLCs using the same motel, right, in an area, is that we're looking at specific periods to make sure there's not overcrowding within that housing inspection request to accommodate those workers on the application. So those are two little strategies that we're looking at to ensure that we catch those employers that are moving workers, right, without notifying CMPC, Chicago National Processing, or EDD, so we can get out there. Thank you.
Yeah, and thank you for mentioning that, Cornelio, because I think independently, both CRLA and EDD had kind of identified this issue of orders coming in with the same housing location. And if you did the addition, as Ruben pointed out, there were 120 workers that are with overlapping housing. And this new system that EDD put into effect a couple of years ago has made a huge difference in terms of being able to identify if there's an overlap and then requiring an additional revision to the order. So that's been very effective, which again, it just reinforces how happy I am to see ALRB looking at these issues, because I think EDD's enforcement, DOL's enforcement, and ALRB's enforcement in many respects resonates much greater with the growers than CRLA going and knocking on the door. And we don't want to sue everybody all the time anyway. I know you think we do, but we really don't.
Thank you both. I think now this has been fascinating. I think we could talk for hours, but I would like to open it up for public comment. Santiago, is there anyone in the queue?
No one standing by in the queue.
Okay. Any others looking for public comment or any other questions? I guess we outlasted them all. Well, this is just, I just want to thank each of our presenters so much for your generous time and for your expertise. I learned a lot, took pages of notes, so I may be following up with you on certain questions, but just really appreciate your informative presentations. And again, just being so generous with your time. And with that, we'll conclude our informational panel. I'll move on to the final agenda item, which is agenda item number 12, which is announcements. As Todd Ratchin mentioned, we are still awaiting a decision in the U.S. Supreme Court case, Cedar Point Nursery v. Hasid. We anticipate that decision will be sometime before July 1st, but we do not know when. And then our next public board meeting and regional directors meeting will be Tuesday, June 8th. Thank you, everyone. This meeting is adjourned.